referred to her as auntie?
Yes.
You never reached out to her on a regular basis when you were in dire straits?
Yes.
You never asked for support from her?
Yes.
You never confided in her when you were deep in trouble?
Yes.
But you didn't have a close relationship?
No. Do you need me to explain?
That's okay. At the beginning of your 911 call, you also referred to her as some woman, intending on distancing yourself from her, making a 911 caller think that it was a stranger.
To me, she was some woman.
Overruled.
To you, she was some woman, correct?
By the time she had attacked me,
Yes or no?
yes, she was some woman.
So, when you called 911, one of the first things you said was, some woman attacked me.
Yes, I said that.
Okay. And, you know, yesterday, for the first time, you told us that when she was returning with the car seat, you tried to keep her out of the house that she lives in.
That wasn't
Yes
the
or
first
no?
time. Yes, I did. That was not the first time I said that.
Yes, it was.
Well,
Objection.
that objection sustained, you're not to comment on what her answer is. The jury's instructed to disregard the comment of counsel.
It's your testimony that it was not your first time mentioning to the police or in one of your statements that you tried to keep her out of the house when she was returning with the car seat. Yes or no?
No, that wasn't the first time.
Okay. One moment, please. You told us at the time you were 21. You told us at the time you were 21,
Yes.
but right now you're 22,
Yes.
and you are a mother of a 2-year-old right now.
Yes.
You came here from Georgia,
Yes.
and your aunt got you a job,
Yes.
and she helped pay for you to get here.
Yes.
And when you got in trouble on occasion with work.
Objection.
I don't know the question yet, so it's overruled at this point.
Your aunt got you the job, and when you would need to take time off from work, you text your aunt.
She was my manager, my hiring manager. And
So did you text her when you needed time off?
yes, she was my hiring manager.
Correct. So before you had the job with your aunt, you were struggling financially.
Yes.
So she really helped you out.
I reached out to my grandmother.
Yes,
Never had.
or
Well,
no?
now wait a minute. You, first of all, that isn't a yes or no answer. You didn't ask it in that form. You made a statement, and she's responding to your statement. So I want you to ask questions and not make statements and wait for a response. Go ahead.
Without your aunt, isn't it true that you wouldn't have been able to come here?
That's not true.
Didn't your aunt give you constant financial support in order to help you and your child come from Georgia to Ohio?
No. Constant? No.
It's okay for just your answer. I'll take it.
Wait. Do not make comments after she answers. Jury's instructed to disregard
Since you've been here, or when you were here, did you ask your aunt on many occasions for money?
Yes.
And did you asking your aunt for many occasions span over a large period of time?
No.
Overruled.
It did not?
No. As she also
Wait for another question.
Do you consider, yes or no, do you consider a year a long period of time?
yes.
So it's your testimony that you did not ask your aunt for money on and off over a long period of time?
Over a year, no. For about the first 4 to 6 months, yes. Can I say something at all?
No, just wait for another question.
I would like to talk about the evening of 8/11/24. Your first statement of what happened was to the 911 operator, correct?
Yes.
And when you reached out to that 911 operator, you did not mention being strangled, did you?
No. I mentioned being attacked.
You did not mention being lightheaded, did you?
I mentioned being attacked, as I was still getting attacked during the 911 phone call.
You did not mention being slammed on the ground by your neck and feeling like you might pass out, did you?
No, I did not. I remember mentioning being attacked, though. I'm not sure I have to say all of that on the 911 phone call.
When you spoke to the police officer, and he asked you to write a statement, did he help you write your statement?
No. He just told me to make things clear, as I was still in panic mode, having an anxiety attack.
It's your testimony that while you were writing your statement, you were having an anxiety attack?
I felt very anxious and still in shock. It had just happened.
So you're telling the jury right now that while you were writing your statement, you were having an anxiety attack? Yes or
No, I was still in anxiety mode. I was still in shock from what had just happened. And all he was doing was making sure I wrote things clear. That was it.
Did the police officer tell you to add specific things to your statement?
No.
One moment, please, Your Honor. Is your computer hooked up?
I'm pulling it up right now.
I apologize for the delay.
I need that,
It's on the ground.
oh.
Your Honor, I'd like to play a portion from Officer Jones' body cam, where he directly.
Hold on, come up here, come up here.
It's your testimony that this whole argument started over your grandmother's keys, correct?
Yes.
And that you all came back from visiting your grandmother. You got home first, correct?
Yes.
And your aunt came home later and she was immediately irate, correct?
Say that again?
Your aunt came home after you
Hmm.
and she was immediately irate, correct?
What does irate
I'm
mean?
sorry. She was immediately angry,
Yes.
okay? And you knew she was angry because you could hear her.
Yes.
And one of the first things you heard her saying was asking for
The key.
the key from her daughter, correct?
Yes, ma'am.
Okay. After her daughter did not answer her, she then asked you, correct?
Yes, ma'am.
And your testimony that you went and showed her where the key was eventually?
Yes, ma'am.
And then you went back to your room but left the door open, correct?
Yes, ma'am.
And then shortly thereafter, she came in your room still angry,
Yes.
and you all got into a verbal argument at this time, correct?
Yes.
And the verbal argument ended when you slammed the door, correct?
Yes, ma'am.
Okay. You left the door closed for approximately 5, 10, 20 minutes, you're not sure, right?
Yeah.
And when you reopened the door, your aunt came back in angrier. correct?
Yes.
And your aunt, out of nowhere, choke slammed you, correct?
She came in, she said the words, "Show me I'm a bitch, show me I'm a bitch,"
So,
and yes.
It was your testimony that your aunt came in and choke slammed you, correct?
Yes.
And by choke slam, you mean she took one hand, put it around your neck, and slammed your body into the space between your day bed and the bed?
Yes.
It's your testimony that the whole time she was in there, she was yelling at you and punching you.
Yes. She had me kneed into the ground.
And it's also your testimony that you were trying to get her off of you by any means necessary, correct?
I tried,
Yes or
and
no?
yes.
Now, isn't it true that you are not consistent with where your aunt allegedly chokeslammed you?
Where?
Correct.
Place or
Please.
where on my body?
First time you spoke about it, you said she chokeslammed you onto your bed. Second time you spoke about it, you said she chokeslammed you in between your bed and part of you was stuck under it.
Yes. The second one is true. Either way,
That's
she
a-
choke slammed me on the bed.
There's no question. So as she chokeslammed you on the bed, or in between the bed, and she's yelling at you and she's punching you, you said this lasts for about 7 minutes, correct?
Lasted for a while, yes.
Okay. And you said that you were not losing consciousness, correct?
No, I felt like I was passing out, or I would pass out.
Okay. That's not what you told the officer, correct?
I'm not sure. What are you asking?
You're alleging that your aunt strangled you and was squeezing your neck and you couldn't breathe, correct?
Okay.
while you're talking to the officer that interviewed you, he asked you specifically, was she squeezing your neck? Did you feel like you were going to lose consciousness from how she was grabbing you? And you did not say yes. You said, I feel like my neck hurts.
Objection.
Okay.
Overruled.
Okay?
I felt like my neck hurt at the time. That it had just happened. It was not much dialogue I could give him, hence why he had to help, well, not help me, but he had to tell me to be more.
Wait, let her finish the.
He had to tell me to be more detailed because I was so at a distraught that I couldn't focus on the story or what had happened. I was still in shock, and like I said, I struggle with anxiety in general. That was big for me. That was too much for me, and I needed to calm down.
All right, hold on. I'll ask another question.
One moment, Judge. Or can we approach?
Yeah.
Sorry about that. So we have a couple different versions of whether or not your aunt was actually strangling you.
Objection.
That's sustained, you can't make a comment, okay? You can ask a question, you can't make a comment. All right, look, I'm gonna give the jurors a 10-minute break at this point. Remember not to discuss the case among yourselves or with anybody else. Don't try to find out any facts from any other source, and don't come to any conclusion until the case is given to you. So quick 10 minutes, okay?
All right.
You can step down and go in the hallway if you want. Off the record, Kathy. The reason I just did that is because when we were up here last time, one of the jurors indicated that Bobby had to use the restroom, so that's the only reason I did that.
But Judge, thank you for letting me use the restroom yesterday.
Emmy said something. Somewhere.
apologize, I don't remember exactly where we were, but it was your statement on direct that after, for some reason, your aunt stopped attacking you in your room, correct?
Not for some reason, because she saw the key.
So your aunt saw the key in your room and stopped attacking you, correct?
Yes.
And it was a single key, correct?
Yes, it was a fob.
Okay. And your aunt took the key fob and laughed and left the room, correct?
Yes, and dashed out the house.
And she went to go and get your car seat, correct?
Yes.
Okay. Now, you had just been brutally attacked, correct?
Yes.
And you were afraid, correct?
Yes.
You didn't know at the time whether or not your aunt was going to come back and continue attacking you, correct?
No, I didn't.
You also had a daughter to protect, correct?
Yes.
You had a lock that worked on your door, didn't you?
Yes.
And your aunt was out of the home for more than 5 minutes, correct?
Yeah, we could say 5 minutes.
And it's your testimony, it was your testimony yesterday that while your aunt was gone, you decided to find a weapon to protect yourself, correct?
Yes.
And then you decided to pace back and forth in front of the door
Yes.
and wait for her.
Yes, I was anxious. I didn't know what could have happened. Like I said, she turned into a stranger
So-
very fast.
You had a working lock on your door, correct?
Yes.
You made a choice to grab a weapon, correct?
Yes.
The fighting or the attack had died down, correct?
The attack had just happened.
However, the attack had stopped, correct?
Yes.
And you got a weapon and waited for her to return, correct?
Yes.
And on her return, you attacked her, correct?
I tried to.
She had the car seat when you returned, correct?
She had dropped the car seat at the door.
She dropped the car seat at the door?
Outside of the door, yes.
She dropped the car seat because you tried to close the door on her, correct?
The car seat was dropped before she tried to get in. You can hear the car seat being dropped. When I figured she was trying to...
Hold on.
Okay.
It was your testimony on direct that you tried to keep her out of the house, correct?
Yes.
And that you were pushing the door, but she was stronger, correct?
Yes.
There's no way for you to actually know when she dropped the car seat, correct?
I mean, you can hear the car seat being dropped if I'm at the door. It might not be valid, but like I said, I heard it.
The conversation, part of the conversation or argument you and your aunt were having before was you stating you will not give her the key because you have to have the car seat, correct?
The conversation was, I will not give her the key because she's not talking to me respectfully. And yes, she wanted me to grab the car seat, but the conversation was, you won't get the key until you learn how to talk to me.
So it's your testimony that you, as a 21-year-old, told your almost 40-year-old aunt that she has to talk to you.
Relationship has...
Hold on. You gotta wait till she's done asking the question before you answer.
That she has to talk to you a certain way for you to do what she asked you to do?
Respect is a two-way street regardless.
Is that your testimony that
Yes.
was your state?
Yes, I was being disrespected tremendously even before that.
So your aunt asked you to go get the car seat yourself, and you said, no, not until you talk to me with respect, correct?
Yes.
And your aunt ended up going outside to get the car seat herself, correct?
Yes.
When your aunt came back with the car seat, you tried to keep her out of the house, correct?
Yes.
Once she got back in the house, you attacked her, correct?
I tried to, yes. Are we forgetting the part that when,
Hold on, wait for a question.
You're also told us that you were terrified of what she might do, but you made the decision to pace back and forth in front of the door waiting for her instead of going in your room and locking the door, correct?
yes.
It's your testimony that, it was your testimony on direct that you had never before that day known that your aunt had a gun, correct?
Yes.
And you had never before that day seen your aunt's gun, correct?
No.
Before your aunt moved in with your grandmother, you used to visit her home, correct?
I used to go over there to wash clothes and do her hair.
And sometimes you used to go over there to have your friends there, correct?
I did that once, yes.
So you spent some time with her at her home.
Never spent time with her.
You spent some time at.
She has a daughter that I'm very close with. Me and her had no close relationship. I've said it.
There's no question.
Stop asking dumb shit.
It's your testimony that after your aunt brought the car seat back, while you were on 911, she grabbed you by the bun
Yes.
and started punching you in the face again
Yes.
for no reason.
Ask her, I don't know. I was calling the police because a gun was pulled out on me and there were children around.
And is it also your testimony that after your aunt punched you or grabbed you by the bun and punched you in the face a couple more times, pulled out a gun and waved it at her family, including children, she then just decided to walk out of the apartment?
She had never stepped back into the apartment until I called the police. So that gun incident happened in the hallway right next to the apartment door. I then walked into the apartment and we had words while she was standing outside of the door and I was standing inside the apartment. We had words about who was calling the police and it was small words. By that time, you would have thought it died down. She already pulled out a gun and it didn't die down. I ended up calling the police. She must have got upset by what she heard me telling the police, who knows, and she then attacked me again while I was facing the other way, and I had a child in my hands. Her daughter was directly in front of me.
Who currently lives in that home?
Me, my grandmother, and my daughter.
You have more space there now, don't you?
Yes.
And that's what you wanted to begin with, isn't it?
Who?
Objection.
Overruled.
That's what you wanted to begin with.
To have more space?
Yes.
I don't I don't know how to answer that.
Okay.
As a mother, after you were attacked, it was your decision to try to protect her by grabbing a metal pole and lying in wait to attack a bigger, stronger, angry woman who had just held you down by your neck, punched you in the face, as opposed to going in your room, locking your door, and calling the police, correct?
Yes.
No further questions.
Redirect.
I have a moment, Your Honor. No further questions, Your Honor.
All right, you may step down, thank you. Next witness.
I'm sorry, Your Honor. Sergeant Paul Kokenauer.
You raise your right hand, please. You swear testimony about gives the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You have a seat and stay close to the mic.
Good morning.
Good morning.
Could you please tell the jury your name?
Sergeant Paul Kokenauer.
How do you spell your last name?
Cokanower.
And where are you currently employed?
The City of Willoughby Hills.
And what is your position with the city of Willoughby Hills?
I'm a sergeant with the police department.
How long have you been a sergeant with Willoughby Hills Police Department?
About a year and a half.
How long have you been with the Willoughby Hills Police Department in total?
A little bit over 8 years.
Prior to being a sergeant, what was your position there?
A patrolman.
Do you have prior law enforcement experience before Willoughby Hills?
Yes.
And what was that?
Several months in the city of Asheville.
So what is your total law enforcement experience?
Around 9 years.
And are you a certified peace officer in the state of Ohio?
Yes.
Went to the academy, certifications, everything you need?
Correct.
Drawing your attention to Sunday, August 11th, 2024, were you working for the Willoughby Hills Police Department?
Yes.
And what shift were you working?
It'd be 7 p to 7 a night shift.
So 7 p.m. to 7 a.m.?
Correct.
And were you in uniform?
Yes.
Badge, presence, obvious police officer uniform?
Yes.
In a marked police car or unmarked?
Marked.
So the police car says Willoughby Hills Police on it?
Correct.
On that evening at about 9:30 p.m., were you dispatched to 2255 Parr Lane, apartment 618 in Willoughby Hills, Lake County, Ohio?
Yes.
And why were you dispatched to that location?
To a physical disturbance between two females.
What information did you have prior to getting there?
On our way there, we were advised that there was a female calling saying she was punched and a gun was pulled on her, and then a second female calling and saying that she was struck with a pipe.
was any sort of ambulance or rescue being dispatched?
Yes, I believe so.
Was it at that point or later on that it was dispatched? If you
I
remember?
don't know. Typically, if there's some kind of physical altercation, they'll just automatically dispatch them and have them staged until we're ready for them.
Oh, so even if they're dispatched, they may not actually be present?
Correct.
When you mean staged, they're just in an area and prepared in case they're needed?
Yes.
At the time you were going there, was it your understanding that the two females were still together, or if they were separated at that point?
That they were separated.
When you arrived at that location, were there officers already there, or were you the first to arrive?
No, Officer Muir and Officer Warren were there first.
When you arrived, what, if anything, were Officer Muir and Warren doing?
Speaking to one of the subjects.
Do you know which person they were speaking to?
Yes, Benita Fryer.
Did you get a chance to see Miss Fryer when you were there?
Yes, I'm not sure if it was walking in or at the jail, but yes.
Okay. If you saw her again, would you recognize her?
Yes.
Did you see her in the courtroom today?
Yes.
If you could point her out by where she's sitting, something she's wearing.
Sitting in between two of her defense attorneys wearing glasses and a gray shirt, brown
The
shirt.
record could reflect an identification of the defendant.
Yes.
So Patrolman Muir and Warren are speaking with Benita Fryer. What do you do?
Myself and Officer Jones go upstairs to talk to the other person involved.
So you go up to apartment 618 to talk to whoever may be there.
Correct.
When the two of you get up to apartment 618, somebody answer the door.
Yes.
Do you know who that is?
I'm not sure. I believe it was the daughter of the defendant, Dayani.
Dayani? And was it fair to say you and Patrolman Jones both entered the apartment?
Correct.
Where did Officer Jones go?
Into a back bedroom to the left.
So when you walk in the door, he took a left to go in the bedroom, back that way.
Correct.
And where did you go?
I was in there. I think I don't know if I went and made sure no one else was in the apartment, and then came back to talk to Dayani.
Okay. So did you see the bedroom where Patrolman Jones was talking with another individual?
Yes.
Who was he talking to?
Shemaya Frierson.
Shemai Frierson? Was that back bedroom well lit, dark? How would you describe it?
I don't remember.
Okay. When you went back into I think you said, was it the living room?
Yes.
Is that where Dayani was?
Correct.
And whose daughter is she?
Benita Fryer.
And how old was she?
16 years old.
Did you speak with her in the living room?
I did.
Where was she in the living room when you spoke with her?
I believe she's sitting on the couch.
How was she acting? What were her mannerisms when you were talking with her?
Seemed pretty calm. Was a little fidgety, like had her hands up by her mouth, but wasn't overly showing too much stress or anger or anything like that.
Okay. But you said she kind of had her hands on her mouth or her face?
Correct.
Did she tell you what she had seen?
Yes.
While you're speaking with Dayani in the living room, are you able to hear anything between Patrolman Jones and Shemaya Frierson in the other room?
Yes, bits and pieces.
Okay, so thin walls, so to speak?
Yes.
After you speak with Dayani, Benita Fryer's daughter, and Patrolman Jones speaks with Shemaya Frierson, do you and Patrolman Jones speak?
Yes.
Fair to say when multiple officers are on scene, you work as a team, different people talking to different individuals?
Yes,
Is that kind of normal practice?
it is.
Did you and Patrolman Jones discuss the information that you had each received from the people you spoke to?
Yes,
Based on the information received, was the information Patrolman Jones received and the information you received consistent?
that's correct.
And what decision, if, strike that. Did that include that a firearm had been present?
Correct.
Based on the information that both of you had received, what, if any, decision was made as to what was going to happen next?
We had a brief discussion about what each had said, came together, and it was determined at that point that it looked like Benita would be going to jail. That being said, he went downstairs to talk to Officer Muir so that they can get together, see what information they have together to make the final determination.
So you guys had an initial decision based on your information, then Patrolman Jones went down to speak with Patrolman Muir?
Correct.
Okay, so Patrolman Muir had not come up to the apartment.
That's right.
When Patrolman Jones went outside to speak with Patrolman Muir, did you stay in the apartment or go somewhere else?
I stayed in the apartment.
Did there come a point that Patrolman Jones came back up to the apartment?
Yes.
And what was your understanding of the decision that had been made regarding Benita Fryer?
That she should be in custody.
I'm sorry?
That she'd be in custody.
Okay, so she was arrested?
Correct.
When Patrolman Jones came back up to the apartment, what was he doing at that point?
To collect statements, pictures, give Shemaya domestic violence packet.
And was that done in her bedroom, or was that done in a different part of the apartment?
In the kitchen.
Is that a well-lit area?
Yes.
We have a brief moment, Your Honor.
Yep.
As Patrolman Jones is in the kitchen talking with Shemaya Frierson, fair to say, at that point, you leave them to do that, and you leave the apartment?
Yes.
No further questions.
Cross-examination?
Thank you, Your Honor. Officer, can you please tell me how to pronounce your name?
The spell the last name, it's Sergeant Kokenauer.
Kokenauer.
Correct.
How you doing today, officer?
Good, yourself?
Good. I want to say thank you for your service.
Thank you.
So, Officer Kokenauer, what police department do you work for?
It's Kokenauer. and
Kokenauer, I'm
it's
sorry.
City of
See?
Willoughby Hills.
Told you.
City of Willoughby Hills.
Willoughby Hills. Okay, how long have you been there again?
About 8.5 years.
8.5 years? And what kind of training did you have?
I went to initially. I went
Okay.
to the part-time one. It was 6 months long.
6 months? Did you have to take any tests or anything, like an examination or anything?
Yes.
Okay.
I finished top of my class.
Can you get a little closer to that mic?
Yeah. I finished top of my class.
Oh, you finished top in your class?
Correct.
Can you explain to the jury what you have to do to finish top in your class?
Well, you have to take the test and final exam, and whoever scores the highest score on the final exam.
And Officer Kokenauer, what does that exam consist of?
Multiple questions with multiple choice answers.
Okay. And if you could describe, like, what are some of those answers? Do they ask you things about the field? Do you ask you things about investigations? Do they ask you things about law enforcement? What are those answers include?
Sure,
What do
it's
those
an,
questions include?
it's an over-encompassing thing. It could be scenarios, ORC, definitions.
Okay. And throughout your training, does that require you to be in the field?
Can you say that again?
Does that require you to do in the field, like when you're in an academy trying to become a police officer, do they require you to be in the field, to do on-field training, like hands-on as a part of your training?
As to what pertains what, as investigations?
Yeah, do you like shadow other police officers? Do you go on rides and stuff like that or no?
Not in the academy, no.
Okay, okay. Is there a time where you do that?
Correct, yes.
Okay, and when is that time?
When I started in Ashtabula, that was what I initially did, was just ride along with an officer, watch how it's been done. During FTL, same thing.
Okay. And why do they have you ride along with the police officers when you first start out? Or do they have you do that when you first start out?
Yeah, well, they usually put you with the field training officer because you don't have the experience.
Okay, so you're trying to learn, right?
Correct.
And you're trying, is it time, do they mentor you a little bit or no?
Yeah,
Okay, and again, you learn from them, right?
yeah, and by doing, and them giving you guidance.
Okay, learn what to do in the field, right?
Yes,
Learn how to conduct yourself as a law enforcement officer, right?
yes,
And would it be reasonable to say, learn how to comply with the rules and laws, correct?
I would say so, yes.
Okay. Now, you testify on direct examination that you received a call about a physical disturbance between two females. Is that correct?
Yeah,
Okay. And you also testified on direct examination, both females called 911. Is that correct?
yes,
So when someone calls 911, would it be reasonable to say that they may be in distress?
yes,
That there may be an emergency happening or has happened?
yes,
And it's your testimony that both my client and the alleged victim called 911.
that's correct.
Now, Officer Kokenauer, why do you investigate? Why do you investigate crimes?
Objection.
Why do I investigate crime?
Yeah, why?
I mean, other than the obvious, it's our job, but to determine if their crime had occurred, well, who would be charged?
And you do that to get details, right?
Correct.
Statements, right?
Yes,
And when you conduct your investigation, right? You deduce it, or you put it into a police report. Is that correct?
that's correct.
Okay. Why do you do that?
For documentation purposes?
Okay. And when you do your police report, you want most of the information in the report, correct?
Yes,
Because you want it to be as accurate as possible, correct?
that's correct.
And you want it to be accurate so it thoroughly depicts what your investigation was, right?
Yes,
And you don't lie in your police report, right?
not intentionally, no.
Okay. Because, like right now, there's a possibility that you may have to testify to it, correct?
That's correct.
Okay. And again, it's your testimony that you try to put all details in your police report, correct?
Yes,
Did you review your police report before you testified this morning?
yes,
Okay. So you're familiar with it, correct?
yes.
Do you remember strike that one moment, Your Honor. Okay, so you remember in your police report where you said around the same time.
Hold on, come up here.
Officer, you read your report, correct?
Sergeant, yes.
Sergeant, I'm sorry.
Sorry.
I'm sorry. People call me a probation officer sometimes, and I get irritated.
Sorry.
Sergeant, you reviewed your police report before you testified, right?
Yes.
Did you ever include in the police report that my client was attacked with a pole? Yes or no?
I did put in there that she stated that she was
Yes
hit
or
the
no?
pole. Yes.
You stated, okay.
I never talked to her. I'm putting in there what was relayed from Central.
Oh. Okay. So those aren't your words in your police report then?
Objection.
Okay, he just said he relayed it. Withdraw.
Wait.
Withdrawn,
All right.
Withdrawn, Your Honor.
Okay.
I'll move on. Sergeant Coconut, when you go to a crime scene or pursuant to a 911 call, what's the first thing you do?
I mean, it's kind of open-ended. I don't know what you're asking me.
Who are the first people you talk to?
Everybody involved.
Everybody involved.
Correct.
Did you talk to Benita then?
There was 4 officers on scene.
Okay, but it's your testimony right now that when you get to the scene, you talk to everybody that's involved. Correct? Yes or no?
Yes.
Did you talk to Benita prior that night? Yes or no?
I was talking to someone else. No.
So you didn't get her side of the story, did you?
Me personally, no.
And Sergeant, after you conduct your investigation, how do you determine who to charge? Well, let me back up. When 2 people that you just testified that 2 people call around the same time, 911, correct? That's your testimony, right?
Yes.
Okay. So have you ever had an instance where that has happened in the past where 2 people at the same time call 911 and you respond to that 911 call? Have you ever had that happen before?
I'm sure it's happened before, yes.
Okay. And when 2 people are calling and accusing each other of things, kind of hard to determine who the victim is, right? And who the perpetrator is, right?
I mean, that's kind of open-ended. It just depends on the circumstances, the evidence, witnesses. I mean, that's just kind of an open-ended
Okay.
question
Well, let
for
me
me.
make it closer for you.
Okay.
Let me make it simpler for you. When 2 people, when on that night, when you were aware that 2 people called 911, were you able to determine which person was the perpetrator and which person was the person that was attacked, the alleged victim? Were you able to determine that at that time?
Can you ask it again?
Yes. When you received the 911 call,
Are you talking about this case, this call?
yeah,
Okay.
yeah. Okay, so let me give you the roadmap. You testified that Ms. Fryer and the alleged victim called around the same time, right?
Yes.
Okay. When 2 people, when you got that information, were you able to determine who was at fault and who was not at fault? Yes or no? At that time?
At that time, no.
Okay, and what do you have to find out in order to determine who's at fault and who's not at fault?
Speak to everybody involved, including witnesses.
Okay, but you didn't speak to everybody, you personally didn't speak to everyone at all?
He's indicated that 3 times.
Okay. And in fact, you only spoke to my client's daughter, is that correct?
Yes.
Okay.
No, that's not correct. I
Okay.
did speak briefly with Shemaiah.
With Shemai?
Yes.
Okay. And when you say briefly, about how long did you speak to Shemai?
I asked her a line of questions about the incident. It was maybe a couple minutes.
Okay, and you said when you guys walked into the apartment building, Patrolman Jones went to go speak to, you guys went up the stairs and everything, and Patrolman Jones went to go speak to Shemaya, correct?
Yes,
Okay, and then you went into like the living room or something?
that's correct.
Okay. And did you when you saw Shemaya for the brief time you saw her, was she calm?
It depends when you're talking. Initially, yes.
And on direct examination, you said you work as a team, right? You and other law enforcement officers work on a team, work as a team, right? If there's multiple officers on the scene.
To make determination, are you asking for like determination on charges?
No, I'm just asking generally, when there are multiple officers investigating a 911 call, right, disturbance, you guys work as a team in that investigation, right?
Yes.
And like you said, when the state of Ohio asked you on direct examination, you guys share information with each other, huh? Right?
Yes.
Okay, because that helps you complete your investigation so you can put in the report, right?
Yes.
Okay. Do you remember speaking with Patrolman Jones that night in the hallway?
I do.
Okay. And do you remember when Patrolman Jones indicated to you?
Objection.
Sustained.
Sergeant, one moment, I just need to read this real quick. Sergeant, did you put in your report that you spoke to Patrolman Jones?
I'm not sure.
If I showed you a report, would it refresh your recollection as to whether you did or not?
Yes.
Judge, permission to approach the witness? Now, Sergeant Kokenauer, that's your report?
Yes.
That's your name?
Yes.
That the date that you wrote the report?
Yes.
Can you read this report briefly? And can you tell me whether you include that you spoke with Patrolman Jones?
No, it does not specifically say that I spoke to him.
Okay. Would you agree that the conversation that you had with Patrolman Jones was important, pertinent to the investigation?
Can you ask again?
Would you agree your conversation with Patrolman Jones about your investigation, would you agree that it is pertinent or important to the investigation?
I would say yeah, just to say that they both lined up their stories. We're the same.
But it wasn't important enough to put in your report.
I mean, not every single detail is put in a report.
Fair enough. So it's your testimony that not every single detail is included in your report, is that correct?
Yeah, that's part of the reason why we have body cams.
Okay, and is it reasonable to say that some things could be left out?
Yes.
Now, how do you determine whether to charge someone?
For us, especially when there's multiple officers, what would we say? Like the lead officer would make that determination. Obviously, being a supervisor, it's something that I would be privy to understand where we're going with what we're doing.
So Sergeant, you were the supervising officer
That's
that
correct,
day?
yes.
And what does the supervising officer do?
Any questions people have as far as if we're not unsure what to charge someone with, general calls to service, same thing as a patrolman would do, I just have like approving reports. Any questions that the patrolman would have, would they come to me for?
Okay, are you like the lead patrol or the lead officer as a supervisor?
For this specific report, this is not mine. No, I would not be the lead.
Okay, so let me back up. For this specific incident, you were a supervisor, correct?
Yes,
Okay. Did you take the lead in this investigation or no?
as far as the report, it comes down to when we get called to a scene, it's usually two people generally. Whoever zone it is, they would be taking the lead on that. They would be doing the typing, and the rest would be for them, or no arrests.
Okay, fair enough. So when you did your investigation, you inquired with other officers on the scene, right?
Yes, I inquired with Jones. Jones inquired with Muir.
Okay. And when you inquired with the officers, did you discuss the details of the investigation?
I can't speak to what Officer Jones spoke to Officer Muir about, but me and Officer Jones had a brief conversation about whether the two people we spoke to did their explanation of the events line up or not.
Okay, and throughout your investigation that night, were you aware that my client was attacked with a pole?
Based on the call, I specifically didn't talk to her, so I don't know what she did or didn't say.
So it's your testimony that you weren't aware that she was attacked with a pole?
Objection.
No, go ahead and answer that question. You can answer that question, go ahead.
Okay, can you ask it again?
Is it your testimony that you were not aware that my client was attacked with a pole? Yes or no?
The witness I talked to said yes,
Okay, so you were aware that my client was attacked with a pole?
based on what Dayani said. I don't know that she was. I didn't speak to her, but yes.
Is there a reason why you left that out of your report?
I have no idea why it was left out.
Would you agree that it's not in your report?
From what I just read, I don't believe it was.
So that's another detail that's not in this report, correct?
He's answered that, though. Okay, let's move on to another question.
Yes, Your Honor. So is it reasonable to say that your report is not entirely consistent with everything that happened that night, yes or no?
I would say no.
You would say no?
That it is consistent.
Okay. And why did you determine, when did you determine who was the victim and who was the perpetrator?
So me and Officer Jones had a conversation. I initially told him to go talk to Amir, made that implication to him, but based on what me and him had spoke to both Benita and Dayani, that based on their statements that it was looking like that Benita would be going to jail.
And as a supervisor on the scene that night, you didn't deem it necessary to talk to Benita?
No.
Okay. Your Honor, may I have one moment?
Yep.
just briefly, Sergeant Kokenauer, did you have a conversation with the alleged victim? Well, you testified that you had a brief conversation with the alleged victim, yes or no?
Yes.
And were you assisting her in writing her statement?
No,
Were you there when she wrote her statement?
I believe so, yes.
Okay, did you hear, were you there when she asked for help to write her statement?
I don't believe so.
Objection.
Overruled.
I was asking questions revolved to the strangulation portion.
Oh, you were? You asked her questions involving the strangulation portion?
Correct.
Let me ask you this. Did you ever hear the alleged victim deny medical transport to the hospital?
I don't believe I was there when that happened.
Did you ever hear her deny the ambulance multiple times?
Objection.
Sustained.
Did you ever ask the alleged victim if she wanted to go to the hospital?
Me personally, I don't believe so, no.
Why not?
I wasn't the one speaking to her.
Through your brief conversation, what did you speak about? You said you talked about the strangulation and everything, right?
How she felt during that time.
Okay. And strangulation is serious to you, right?
Yes.
Okay. So you didn't think you would ask her if she needed medical attention while you were talking to her about that?
I mean, she was conscious. I didn't see any need. I'm not sure if we had already called for one. I'm not really sure what transpired at that point.
So you never asked her if she needed medical attention?
Me personally, no.
Because she didn't look like she needed medical attention, did she?
I'm not sure what Officer Jones asked her, didn't ask her.
Okay, I'm just limited to your conversation. You didn't ask her if she needed medical attention, did you?
He's stated that
Okay.
multiple times now.
Okay. It didn't look like she needed medical attention, did it?
I'm not a medical professional, but not from what I could tell.
Well, you didn't see her grabbing her neck when you talked to her, did you? You didn't see her grabbing her neck, did you? Like she couldn't breathe, right?
Objection.
Overruled.
Was she grabbing her neck?
You didn't see her grabbing her neck.
And what?
indicating she couldn't breathe, right?
I don't know if that would indicate she couldn't breathe or not. I guess I'm not sure what you're asking me. Did she grab her neck in front of me? No.
When you spoke with her, initially, did you see any injuries on her?
I don't recall.
Did you see any swelling on her neck?
I do not recall.
Did you see any bruises on her neck?
Objection.
Overruled.
I do not recall.
One moment. Last question. Did you ever ask the alleged victim if she lost consciousness?
I
Yes or
asked if
no?
she felt like she was.
Let me rephrase the question. Did you, sir, yes or no? Did you ever ask the alleged victim if she lost consciousness? Yes or no?
I don't remember.
Did the victim ever tell you she lost consciousness? Yes or no?
No.
No further questions, Your Honor.
May redirect.
Thank you, Your Honor. Sergeant Kokenauer, when multiple officers respond to a scene, does each officer speak with each person on the scene?
No. Not typically.
When there are multiple officers, is it fair to say you work as a team, you split up to speak with everybody?
That's correct.
And in this instant, on August 11th, 2024, when you responded to Parr Lane and eventually Apartment 618, were all the people that you thought were witnesses that could have information, were all of them spoken to by at least one officer?
Yes,
Fair to say you rely on each other to each do your job so that you can come together and work together?
that's correct.
So did one or more officers speak with Benita Fryer?
Yes,
And you spoke with Diane Fryer, is that correct?
that's correct.
And then Patrolman Jones spoke with Shemaya Frierson?
Yes,
Fair to say each officer can document their own interactions and aspects of what they were involved in?
that's correct.
So it's not just what you write, it's what every single officer writes together that becomes the report.
Yes,
And then the body cams are also attached as part of the report.
yes,
When you are so is it fair to say your report's not inconsistent, it just didn't necessarily have every detail?
that's correct.
When you were responding to dispatch, going to a location, do you hear the actual 911 calls?
No,
You're just receiving information from dispatch of what they have heard.
that's correct.
So fair to say bits and pieces.
Yes,
When Patrolman Jones was speaking with Shemaya Frierson in the kitchen, is that when you spoke with her briefly?
yes.
Were you looking at her for injuries at that time?
Me personally, no.
So Patrolman Jones was handling sort of that aspect of of speaking with Shemaya Frierson?
Yes,
Did you ask Shemaya if she felt like she might lose consciousness?
I believe so.
So you were gathering more information to see if the charge of strangulation was something you would charge. Is that accurate?
That's correct.
And was a determination made to charge strangulation?
Yes,
And is it accurate to say that an ambulance came, paramedics came in and saw Shemaya Frierson?
yes.
No further questions.
Any recross?
Briefly. Detective, you talked to and redirect about your investigation, everything. This was an apartment, right?
Yes,
Okay, multiple rooms?
I believe
Multiple
so.
rooms, like exterior rooms, like different dwellings in the apartment? Like different apartment rooms?
Like different
Like-
bedrooms, or are you talking apartments
Like
outside?
apartments, like there's a door right here to one apartment, and there's a door right here to another apartment, and there's a door right here to another apartment.
Yes, there's a hallway with
Okay.
multiple doors.
Okay. Detective, did you interview anyone else? Did you knock on doors and interview anyone else throughout your investigation?
I did not.
Do you know if anyone else did?
I'm not sure.
Do you know if anyone else pulled any video from the hallway or anything?
I'm not sure.
Did anybody do any follow-up?
I can only speak for myself. I'm not sure.
Did you do any follow-up?
No.
No further questions.
You may step down, thank you. Next witness?
Call Patrolman Richard Muir.
Raise your right hand, please. Swear testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God. Yes, Your Honor. Proceed.
Good morning.
Can you please tell the jury your name?
First name Richard, last name Muir, M-U-I-R.
And where are you currently employed?
City of Willoughby Hills.
What is your position at the City of Willoughby Hills?
Patrol officer,
So you're at the Willoughby Hills Police Department?
that's correct.
How long have you been with the Willoughby Hills Police Department?
Since February 2023.
So a little over,
2 years, coming up 2.5 almost.
prior to working for the Willoughby Hills Police Department, did you have prior law enforcement experience?
Yes, I did.
And where was that?
Village in Boston Heights, which is in Summit County, just about 15 minutes north of Akron.
And how long were you at that location?
5 years.
So fair to say total law enforcement experience, a little over 7 years?
That's correct.
Are you a certified peace officer in the state of Ohio?
Yes.
Fair to say you went to an academy, completed academy work?
Yes.
During your just over 7 years of total law enforcement experience, during that time, do you have experience with domestic disturbance or dispute calls?
Yes.
Since you, we'll focus on Willoughby Hills. Since you've been at Willoughby Hills Police Department, how many cases would you say of domestic disputes or disturbances would you get on, say, a weekly basis?
Weekly, it can depend. Summertime is a lot busier, so on average about 2 to 3.
And how many of those, or how many a week or a month include physical violence?
Again, it depends. We've had some very busy months in the summer, and then we've had some very slow months. But I'd say an arrest happens about 2 to 3 times a month for physical domestic, at least on our shift.
Do you have trainings that dealt with domestic disturbance disputes, things of that nature?
Yes,
Does the academy cover some of that?
it does.
Fair to say, on-the-job training, the more you go to, the more you learn?
Yes.
Are there other trainings that you have that help with that experience or knowledge of domestic disputes or disturbances?
Yes.
And what's that?
So I'm certified as a CIT officer, which is a crisis intervention training officer. I'm also a field training officer for the city of Willoughby Hills, stuff like that.
And then do you do in-service trainings, things that as issues come up, the department just for training and knowledge continue to do that?
Yeah, so the city of Willoughby Hills, we put on our own in-service training once a month for each platoon that we have, and we have 4 platoons, 2 day shift platoons, 2 night shift platoons. And it kind of rotates what we specialize in that month, but it does cover first aid, CPR, it covers traffic stop stuff, covers domestic violence, building searches, seizures, law updates, etc.
I'm going to draw your attention to Sunday, August 11th of 2024. Were you working for Willoughby Hills Police Department that day?
I was.
What's your shift or what hours were you working?
7 p.m. to 7 a.m. midnight shift.
And were you in uniform or plain clothes?
I was in uniform.
Does that have your badge present, identified as Willoughby Hills Police Department officer?
That's correct.
Were you in a marked police car or an unmarked car?
Marked?
And does the car say Willoughby Hills Police on it?
Yes, it does.
About 9:30 p.m. on August 11, 2024, were you dispatched to 2255 Carter Lane, apartment 618 in Willoughby Hills, Lake County, Ohio?
Yes.
And why were you dispatched to that location?
We received 2 911 calls from 2 different individuals that Central basically told us there was a physical altercation between 2 females. One alleged that she was punched multiple times and a gun was pulled on her, and then the other female alleged that there was some sort of pipe or pole that was used against her.
the time that you're responding, is it your understanding that they are still together or they are separated?
They're separated.
And what was your understanding of where the individuals were?
So Central had advised that one individual was in a parking deck area. Because there's numerous high-rise apartments there, there's different parking areas. So one of the individuals was in that parking lot area, and then the other individual was actually still in the residence, so the apartment.
Were you the first officer to arrive, or were other officers already there when you arrived?
I was first to arrive, but Officer Warren was very shortly behind me. It wasn't maybe a few seconds.
Okay, so the two of you were basically the first to arrive.
Correct.
And when you got there, who, if anyone, were you looking for?
Can't recall, but I do remember there was a female that was walking towards us from the parking deck, and Central advised that the female was going to be Benita.
Okay, so your information was Benita Fryer was coming from the parking area?
Correct.
Okay.
Yeah.
And you saw a woman coming from that location? Did you verify who it was?
Yeah, so there were multiple people outside. Again, it was a summer night, so it was decently warm out. So I saw a female walking towards me, and I asked, "Are you Benita?" She identified herself as being Benita, and then we walked up towards our cruisers a little bit more.
Okay. And she walked up towards you and Patrolman Warren?
Correct, yep.
Okay. Do you remember what she was wearing?
It was like a hot pink colored tank top and some spandex type shorts.
Now, based on the information of a handgun or firearm, what, if anything, did you do when you first interacted with Benita Fryer?
Yeah, so she had a purse kind of on her right shoulder area, and I asked for consent to search the purse to make sure she didn't have a firearm on her. She indicated that the firearm was located inside of her vehicle, but just for our safety reasons, while we're talking to someone, we don't want that to be an option, so we asked for consent to search her purse, which she granted.
Okay. So no firearm was found in her purse?
No.
Okay. Nothing on her?
Nope.
Okay. With your first interaction with her, did you notice any injuries, facial injuries?
No.
At that point, you're just asking her what occurred, or what are you doing at that point?
Yeah, so anytime a altercation kind of happens, whether it's family members, non-family members, people that live together, I try to get like what their relationship is to start out, so that way I can see if we only have assault or if this fits a classification of domestic violence. And that's where I kind of start with everybody, and that's where I started with Benita that night, and then move on from there.
Okay, so what information did you get from her about relationship or living arrangements?
Yeah, so she indicated that she had recently moved in to apartment 618, and that was actually her mother's apartment, but she moved in with her daughter, and then who also lived in the apartment was her niece, and then her niece's daughter.
And what was her niece's name?
Shemaya Frierson.
And did she indicate who had lived there first, or the order of people moving in?
Yes.
And what was that?
So Shemaya and Shemaya's daughter had moved in first, and then Benita had moved in approximately 4 months prior to the date of that incident with her daughter.
And for this evening, when you're talking, was it your understanding that Benita Fryer's mother was home or not home?
She was not home.
Did Benita Fryer then tell you what had happened that evening?
Yes, she did.
what information do you remember that she told you?
So she indicated that her mother, again, the leasee of the apartment, had recently suffered a stroke the day prior. So they had been dealing with whole issues and stuff like that. And then she indicated that she got into some sort of altercation with her niece, Shemaya, over her mother's keys or key fob 2025
So her mother's vehicle?
vehicle, yeah.
And during this interaction, well, before we get there, do you see Benita Fryer in the courtroom today?
Yes, I do.
Could you please identify her by where she's sitting, something she's wearing?
Yeah, she's sitting in between her two defense counsels wearing a polo button up and some glasses.
The record could reflect an identification of the defendant.
Yes.
During your conversation with Benita Fryer, do you have your body cam on?
Correct.
And that was recording your interaction with her?
Correct.
Marking for purposes of identification, State's Exhibit 5, showing to defense counsel. May I approach your Honor?
Yep.
I'm showing you what's been marked as State's Exhibit 5.
Okay.
Do you know what this is a recording of?
That'd be my body camera footage.
And have you watched this disc?
I have.
And how do you know that?
I watched it. This is also my signature and my badge number on the disc.
So after you watched it, you marked it so you'd know when you saw it again?
That's correct.
And the part of your body camera that's on here, what's on here is fair and accurate as to what it shows.
Correct.
Your Honor, I'd ask to admit State's Exhibit 5 and publish to the jury.
Is there any objection to Exhibit 5?
No objection, Your Honor.
All right, what's the play time on that, do you think, roughly?
I believe it's 7 to 8 minutes.
Okay. All right, we're gonna take a break at this point, about 10 minutes or so. Remember not to discuss the case among yourselves or with anybody else. Don't try to find out any information from any other source, and do not come to any conclusion until the case has been submitted to you.
You are? Are you Benita? What's your name? You are? Okay, come here. What's your name? Okay, come here. 7-4, I would Benita. 7-4, I would Benita. Do you have your firearm in your purse?
No.
You might for check. Thank you. Do you have your firearm in your purse?
No.
You might for just check. What's going on? Thank you.
No problem.
Just for our safety.
I
Let's come up on the
understand.
sidewalk. What's
in case
going on?
anybody
Wants to come through.
First thing first,
Yeah, let's come up on
my
the
mom
sidewalk
is
in
in the
case anybody
hospital.
wants
She
to come
just had a
through.
stroke. First thing yesterday.
Okay.
Is this something? My mom is in the hospital. She just had a stroke.
Wanted to make sure no.
I don't even know.
Okay.
Is this something I'm drilling in?
No. Just what happened? Wanted to make sure no.
I don't even know. So, well, today, drilling is
Okay.
going.
Just what happened
Like I said,
today
mom
with?
in hospital, so she had my mom. So, well, today, my mom, like I said, mom in hospital, so she had my mom's car key. So I said, you can't drive my mom's car.
Who had your mom's car key?
My niece.
Okay.
So I said, you can't drive my mama car around. Something about, because she in the hospital. Driving back and she was like, well, she don't have no gas. I said, something about, but you can't drive my mother's driving back and forth to the hospital around. She don't have no gas. I said, okay, but you can't drive my mother's car around Washington Hospital. I said, well, you should. She's talking about, bitch, I don't give a fuck. Just slammed the door in my face. I don't give a fuck. I don't give a fuck. I said, well, you should give a fuck. Bitch, I don't give a fuck. She slammed the door in my face and said, bitch.
How's that confusing?
Well, no, everything started to diffuse. So I went in the
How's that confusing?
Well, no, everything started. I went into the living room. So I went in the living room. No, de-escalate.
Okay,
I went into the living room. She slammed the door in my face, so I couldn't see her.
Okay.
So everything was cool.
Your niece.
Yeah. Then
We already checked. Have self-stairs.
is the what? Oh.
Your niece.
Yes.
We already checked.
So, she then was talking on the phone to somebody. So, about the situation. She then was talking on the phone to somebody
Plus percent. Where's your
about
niece?
the situation.
Still
Yeah,
upstairs?
saying this, and that. So I said, Shamaya.
Do we want plus percent? Where's your niece? Still upstairs?
Yeah, she's still upstairs. So as I was sitting in the
want
living room, 618, talking
Sent
about it on the
to
phone with, I don't know who
Thanks.
else.
Okay.
So as I was sitting in the living room, she's talking about it on the phone with, I don't know who else.
Okay. Okay.
Yeah, she had a big old pole hitting me with it.
Okay.
So, which I don't know if I got something about
Okay.
it. Yeah, she had a big old pole hitting me with it.
Okay.
Which I don't know if I got something about it, but she did hit me in my head, but like I said, my adrenaline rush. Huh? I'm sorry. This is my daughter. She probably. I'm talking to the police. Huh? I'm talking to the police. My daughter's upstairs. I'm downstairs. I will call you back.
Your niece was on the phone. How old is your
My
niece?
daughter's upstairs too. She's
So,
21, 20.
okay. Your niece was on the phone with someone in her room.
Yeah, she was on the phone. 21, 20.
Okay.
And she was
So
talking
she
about
was
it.
on the phone with
And
someone
then she was
in
talking about, I
her
don't give
room.
a fuck. Yeah, she was on the phone. My mama's car. And she was talking about it. And then she was talking about, I don't give a fuck. Something about my mama's car. So I go in there again and say, Shamaya, she's like, I don't give a fuck. Get the fuck out of here. Drive my mother's car while she's in the hospital. Yes, I grabbed her leg. She's like, I don't give a fuck. Get the fuck out of here. But after that, it kicked me. When she kicked me, yes, I grabbed her leg and I dragged her off the bed. But after that, it started escalating. But it was a tussle. It was a fight. It was a tussle. So I just held her down on the ground. But it was a tussle. She's like, I don't give a fuck. I don't give a fuck. So I just held her down on the ground and said, Shamaya. She's like, I don't give a fuck. 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 And she's like, man, I'm about to little her reaching for something. Stop, because I will fuck you up. Just reaching for something under the bed. She finally came down. Stop, because I will fuck you up. Just stop. So she finally came down. She finally calmed down. So that gave me a chance to get up because I wasn't trying to get up and then she hit me while I was trying to get up. So she finally came down as I was holding her down and I got up. It was cool. I left.
Daughters?
No,
Her daughters, okay.
my car seat out the car.
Your daughters?
She's about to drive my mom's
Her
car.
daughters, okay.
Because it was in my mom's car.
Okay.
Because like I said, she's about to drive my mom's car while she's in the hospital.
Okay.
My mom has a 2025 car seat. You're not about to drive my mother's car. And took it upstairs as I was. So I went to go get her daughter's car seat. I hear her by the door again. And took it upstairs as I'm taking it upstairs. I hear her the situation by the door again on the phone talking to somebody. I knocked talking about the situation coming in. So I'm thinking as I knocked coming back in because I wanted them to know I'm coming in. So I'm thinking that she can get away from the door because I'm coming back in. So I'm thinking you want to go back in your room and get away from the door. No.
Okay.
She wait for me to come in and have a big ass pole and start hitting me with it.
Okay.
So when she started hitting me, I
like a
just
broomstick
start
or
grabbing
like
it
what
and I
kind of
pull
pole
her
is
back
it?
and forth
Like
with
a
it.
metal rod, is it like a
like-
broomstick or like
It
what
was
kind
a
of pole is
metal
it?
rod
Like
pole. It was
a
like-
metal rod
It was
pole
like
or?
it was a metal rod pole. It was like
I got
lines,
it. Okay.
pull-up bar that you put. I don't know where it came
Okay.
from.
So now you guys are fighting over the pole. I got it.
Yes.
Okay.
Now we was fighting that for the pole. And I'm like, I don't know where it came from.
So now you
And
guys
I'm
are
like, you
fighting
want to
over
get
the
weapons?
pole.
And I did say, I was fighting that for the pole.
Okay.
And then I'm like, you want to get weapons? And I did say, I will shoot you. But
So you
But I
never
did zone was in
had
the
it
car. No.
upstairs, you
But
never
that's why
had
she
it
said,
in
I gotta
your
give me a,
purse.
but no.
So you
her, I
never
did because
had it
no.
upstairs, you never
No.
had it in your
It's in my
purse.
vehicle. No,
Oh, no, you,
because I think it say no guns on this thing somewhere.
no, you,
Yes, I know. No, when I was on the phone, that's what I saw. She said I had a gun. When I was on the phone dispatch, I think she called the police. No, when I was on the phone, she said I had a gun. Because when I was on the phone dispatch, I think she called the police, but I was calling the police already because she had this weapon. And I said, you a crash out. Now you about to go to jail because you hit me with a weapon.
in 618 here with her, or like
Yes, my mom's staying here.
in
But my mom-
618?
Yes.
Okay.
But again, my
And
mom's in
she
hospital, so
stays
I've been
here as
staying
well?
here.
So
since
you all
April.
stay here together? Okay.
Yes.
And
After I
she
was
stays
dropping
here
off
as
the car seat, I
well?
was honestly about to get
So
my
you
stuff.
all stay here together?
Yes. But I couldn't do that because she wouldn't let me. I was honestly about to get my stuff.
But like you reside here, get mail. and
But I
stuff
couldn't
like
do that because she
And
wouldn't let
she
me in the house
resides
because she
here,
started
gets
hitting me with the
mail.
pole.
But like you reside here, get mail and stuff like
Yes.
that. Okay. And she resides here, gets mail and
I
stuff like
believe, so, yeah, because she's from Georgia. So
How
yeah,
long has she been?
has to.
How long has she been? Since before you or after you?
She was here before me because I was staying over there.
Since before you or after you?
She was here before me because I was staying over
Oh,
there.
gotcha. You just pointed at
So,
some.
yeah, I don't know which over she was.
Oh, gotcha. You just pointed at some.
Yeah, I don't know which because she yeah, I was going to go get my stuff after I dropped took her car seat in because I got my mama key. But yeah, I was going to go get my stuff after I took her car seat in because I got my mama key. I didn't care about nothing else but my mother's key because I don't want that girl driving where the key. When I was holding her down, I was like, where the key? So that's and she was like, I'm not telling you. I was like, where the key? When I was holding her down, I was like, where the key?
So
And she was like, I'm not telling you. I'm not telling you.
you.
But I saw it on the bed.
So after you came back the second time, you guys knocked and came in.
Yes,
And you
I
guys would
knocked- I
fight
had the
the
key,
second
but I
time.
knocked
You
so
guys,
she'd know
you
that.
knocked
But you
and
guys were
came
fighting
in.
over the pole.
Yes,
And you
I
guys would
knocked. I
fight.
had the key, but
Yeah,
I knocked
and then you
so
guys
she'd
got
know that.
separated. But you guys were fighting over the pole. How
I think because
how
I
did
probably
it
took
end and
control
you guys
of the
got
pole. I think
separated?
know that she didn't have an upper advantage took control of the pole. I think she hit me. It's like I didn't really know that she didn't have an upper advantage because I was like, she started hitting me trying to grab it while she's swinging. And I'm just like, but I got hit with the pole because I was like this, trying to grab it while she's swinging. And I'm just like I said. And so when she's swinging it, I'm grabbing it and I pulled it.
And then once you got the pole from her,
I didn't take it fully from her,
and then
but I dragged her. But
once you got the pole from her,
I didn't take it fully from her,
Yeah.
but I dragged her
Into like
and
a
then she
room
went
or
back in the house. No, she
she
went
went
right by
back
the
in.
living room.
Okay.
Again, and she went back
Into like
in
a
her
room or something? Or?
No, she went right by the living room.
Okay.
Again,
Okay. And then we
and
showed
then
up.
when I went, she went in the house and I
Gotcha.
left.
Okay. And then we
and
showed
then
up.
when I went,
Okay. Cool.
she went in the house and I left.
And then we showed up and
Yes.
here we are. Okay. Cool.
So, State's Exhibit 5, that's you speaking with Benita Fryer,
That's correct.
and that's outside the Pine Ridge Apartments, 2255 Parr Lane.
Correct.
While you were speaking with Benita Fryer, did you see any injuries on her face?
No.
Did you see any other injuries on her?
Yes.
What did you see?
She had a scratch on her right pinky finger. She also had a scratch on the inside of her right bicep, on her left shoulder, almost by where like a female's bra strap would be. She had a scratch on top of her shoulder area there, and then she also had the scratch that you saw in my video where on her thigh area, some sort of scratch there as well.
And that was on the left
The
thigh?
left thigh outside, yes.
Based on your training and experience, what, if anything, did the injuries look like to you?
So those injuries, again, going on domestics quite often, were very consistent with some sort of defensive wounds from another individual.
So somebody was defending themselves
Correct.
against Benita?
Correct.
Did Benita Fryer wish to have an ambulance?
No.
So she was asked.
Yes.
While you're speaking with Ms. Fryer, do other officers, and as you could see in your video, Sergeant Kokenauer was there at some
Correct.
point. Who else arrived?
Officer Jones.
Where did they go while you stayed with Benita Fryer?
So myself and Officer Warren stayed downstairs with Benita because we had already made that first contact and had that rapport already. So I asked Sergeant Kokenauer and Officer Jones to go upstairs to make contact with Shemaya.
Benita Fryer's daughter was also upstairs?
Yeah, I believe it was while talking with Benita.
Is it normal procedure for, when there are multiple officers, to split up to talk to different individuals?
Yes, it is.
Once everybody talks to everybody else, is it fair that that information is shared for any determinations?
Yes.
Did you have occasion that evening after speaking with Benita Fryer to go to her vehicle?
Yes.
Where was her vehicle?
So right where we were, there's a right in the middle. There's some offices. There's an indoor pool. There's a little workout gym for residents of Pine Ridge Apartments. Right behind there is an upper parking deck, and then underneath, under the ground, there's another parking garage. Her vehicle was parked on that upper parking deck, right behind that office pool area.
So when you first saw her, she was coming from the direction of where her car was?
Correct.
So do you know what type of car she had?
I can't remember off the top of my head.
Okay, but you went to her vehicle with her?
Correct.
Okay. And what, if anything, did you locate inside the vehicle?
Yeah, so since there was a firearm alleged or in play, we wanted to at least get the firearm and have it secured in one of our patrol cars while we concluded our investigation, conducted it. So Benita consented to us going to her vehicle. She gave consent to us going inside of her vehicle to retrieve the firearm. She unlocked her vehicle for us. I asked her where the firearm may be inside of her vehicle, and she stated that it was either going to be in the center console or in the glove box. So the first place that I checked was inside the center console of her vehicle. That's where I located a Smith & Wesson MMP 9mm handgun. It was in a soft case purple holster in the center console. So I removed it from the center console. I removed the firearm from the soft case holster. I ejected the magazine, which was loaded, out of the magazine well of the firearm. And then I racked the slide a couple times to make sure it rendered the firearm safe, and a 9mm round came out of the slide, so the firearm was loaded.
So there was there was a live round in the chamber?
One live round in the chamber, and then loaded magazine in the magazine well. So then after that, I ran the serial number through our central dispatch, and then we walked back up to our patrol cars where I secured the firearm locked in my patrol car.
At any point, did you go up to the apartment?
No.
And did Patrolman Warren stay with you the entire time with Benita Fryer?
While at Pine Ridge?
Correct.
Yes, yes.
So he didn't go up to the apartment either?
No.
And Mark, for purposes of identification, Exhibit 6. Showing to defense counsel. May I approach, Your Honor?
Yep.
Showing you what's been marked as State's Exhibit 6. Do you know what is in that box?
The firearm that I retrieved out of the vehicle from Benita, the holster, and the magazine, and all the ammo.
And how do you know that this is the same firearm that you took from Benita Fryer's car?
All my handwriting is on the box, labeled, and it was sealed by me before I placed it into an evidence locker and then sent to the county crime lab for operability.
And do you, when you seal it, do you put your initials on it?
Every piece of tape that all sides, my initials are on.
Okay, so the RM on this clear tape is from you?
That's correct.
Okay. And the writing kind of on the left side of the box, that's what you're talking about, is the information you fill out for what's inside the box?
That's correct.
So fair and accurate for everything that you have done?
Yes.
I'm just gonna show you State's Exhibit 4. Do you know what that's a photograph of?
Yes.
Your Honor,
Yeah.
may I go over to see what's being shown?
Sure, shown for.
What is it, the photograph in State's Exhibit 4?
That is the Smith & Wesson M&P 9mm handgun, the soft purple holster, and then the magazine with the live ammunition.
And this State's Exhibit 4, that photograph are the items that are within State's Exhibit 6?
Correct.
And I'd ask to move State's Exhibit 4 into evidence and publish it for the jury.
Any objection to 4?
No, Your Honor.
4 is admitted.
And just so that we're clear, State's Exhibit 4 is now up on the screen. Clear to say that the items you described are
Yes.
shown, and that's what's in State's Exhibit 6.
Correct.
So you mentioned that after you go to the vehicle, you walk back out of the parking area, so that you're back in the main area, so to speak, of Pine Ridge?
Correct.
Outside still?
Correct.
Does Patrolman Jones come down from the apartment to speak with you?
Yeah, so I actually requested either him or Sergeant Kokenar come down so we could converse both stories.
Okay. And based on the information you had received so far, where was your thinking?
My thought process was that at the very minimum, we had domestic violence charges going against Benita being the primary physical aggressor in the incident. That's basically what we look for in all sorts of domestic violence in the state of Ohio, is who's the primary physical aggressor. And based off her story, she admits that she overpowered Shamaya.
When Patrolman Jones came down, was he able to share information with you about the individuals that were spoken to in the apartment?
Yes.
Who is your understanding of who was spoken to in the apartment?
It was my understanding that Patrolman Jones spoke to Shamaya, while Sergeant Kokenar then spoke to Dayani, the Benita's daughter.
So was the information you received from Patrolman Jones about the other individuals consistent with each other
Correct.
and consistent with your beliefs at that point regarding Benita Fryer?
Correct. There was only one difference, and the difference was that what Patrolman Jones had told me about a firearm being pulled out was Benita never told me that she had pulled out a firearm, but she mentioned that, obviously on my body camera, the threatening that I will shoot you.
And then did Patrolman Jones let you know that Shamaya had talked about a colored holster,
Yes.
and that was consistent with what you had found in Benita's vehicle?
Correct. Yeah, I had not mentioned any color to Patrolman Jones when he came down. He had just heard that I had located a firearm and secured it in my cruiser, because he heard over the radio. And then when he mentioned the purple holster, I was like, that's funny because I have a purple holster.
Okay. Was Benita Fryer placed under arrest?
Yes.
Have a brief moment, Your Honor. No further questions.
Cross-examination?
Morning, officer.
Good morning.
So on direct, you talked about all the training you've been through, correct?
Correct.
So you've been trained on how to respond in different situations. So for example, when you got the 911 call or the dispatch and you were told there might be a gun involved, that changes how you respond, correct?
Correct.
And the reason for that is, number one, officer safety, but also safety of the public, right?
Correct.
And so, once you arrived on scene, your first priority was to secure the scene, correct?
Correct.
And so, when you saw Benita, the first thing you wanted to do was make sure that the gun you were told about wasn't on her, correct?
Correct.
And so, when you asked her about it, she was extremely cooperative with regard to allowing you to go in her purse and search her so that you would be at ease, correct?
Correct.
It's your job to be unbiased in the way you gather facts and collect information, correct?
Yes.
It's critical for you to remain unbiased while interviewing witnesses and reporting what you learned, correct?
Yes.
It's critical because in these situations, as you testified, when one officer talks to each person, you're the only one getting that information, correct?
Yes, because there's multiple officers on scene.
Right. And so you have to make sure that you relay what you learned to the group so that they can take all of it into consideration when deciding what's going on, correct?
Yes.
You've also been trained to observe and report the demeanor of witnesses in domestic violence disputes, correct?
Yes, it's documented in my report.
You've been trained to do that, correct?
Yes.
In this situation, Benita was legally able to own her gun, correct?
I don't remember. I'm going to say yes because she wasn't charged with weapons under disability, so I believe so.
Okay. And on direct, you stated that you were a certified crisis intervention officer,
Correct.
and you've got 7 years of experience as a police officer?
A little over.
Okay. Were you the lead officer on this case?
Yes.
Did you do any follow-up here?
As far as,
Anything?
I mean, back at the jail, I offered a witness statement to Benita. She declined to pursue one. I asked if she wanted to press charges against Shemaya. She declined.
Did you attempt to get surveillance video of Benita allegedly pulling the gun out in the hallway?
There is no video.
Did you try to get it?
Is your question done?
Did you try to obtain video?
There's no videos in the hallway of Pine Ridge Apartments.
So there's no surveillance there and there's no doorbell videos?
I never went to upstairs, but from past incidences at Pine Ridge, domestic violence in the hallways, anything else, there's no hallway video in Pine Ridge Apartments. And that's 3 different high rises that don't have any video.
But to answer my question, you didn't do follow-up here.
There was no follow-up needed.
Did you do follow-up here?
There was no follow-up needed.
Could you please just answer my question?
Well,
Objection.
the answer is apparent that he didn't do any because there was none needed, so let's move on.
So, you would agree that it is important to remain unbiased whenever you're collecting information and writing it down in your report, correct?
That's correct.
Do you believe using words like claim when referring to someone's statement is unbiased?
Yes.
Do you believe describing someone's actions as admitting to doing something as unbiased?
Yes, and I can explain.
I don't need you to.
Okay.
You stated on direct that before you got any information from anyone else, it was your opinion that Benita should be charged with domestic violence because she overpowered Shamaya, correct?
Yes.
And that she was the primary aggressor?
Primary physical aggressor, correct?
However, it was Benita's testimony that Shamaya kicked her first, correct?
Correct.
And it's Willoughby's policy to determine primary physical aggressor, correct?
Willoughby Hills.
Willoughby Hills.
Yes, correct.
You guys don't use predominant aggressor, correct?
It's primary physical aggressor.
Just a question. Okay, thank you.
Mhm.
Is it your practice to leave out, sharp that. It's true that you left out a lot of what Benita told you when you spoke to the other officers, correct?
I don't remember, to be honest with you.
Okay. Well, you told us that based on your evaluation and that you thought she should be charged after you spoke to her, correct?
Correct.
And at what point in that conversation did you make that decision?
In my conversation with Benita, or in my conversation with Officer Jones?
With Benita?
I don't remember when I made that determination.
Okay. In your report, well, actually, just now, you stated that you asked Benita if she wanted to press charges against her niece, correct?
Yes.
When did you ask her
Probably shortly after that, my body camera cuts out there.
Okay. And her response was no?
Something similar to that, yes.
Did she give a reason?
I don't remember.
Okay. You said something similar to no?
Yes.
Okay. And do you remember when you asked her if she wanted to write a statement?
I want to say it was either right before Officer Jones came down and talked to me, or when we arrived at the jail, one of the two.
When you spoke with Officer Jones, you didn't tell him about Benita's injuries, did you?
I can't recall.
Would you agree that's pretty important?
Sure.
And would you agree that those injuries are actually consistent with what Benita told you happened?
All she told me that happened was she got kicked and struck with a pole, but not really struck with a pole because she was grabbing at a pole.
That's all she told you?
Well, I mean, there's more, but that's most of it, yes. So I don't, can you rephrase, say the question again?
So your testimony, one second, I'm sorry. Officer, you took some
Yes.
photographs of her injuries, correct?
Yes.
If I showed you those pictures, would you remember them?
Yes.
Showing in prosecution. Your Honor, may I approach?
Yep.
Officer, I am showing you what is defense exhibits E through J.
Okay.
So here is exhibit E. Do you recall this?
Yes.
And we've got exhibit F. You recall this one?
Yes.
G.
Yes. Sorry, it's just how it was.
H.
Yes.
I.
Yes.
And J.
Yes.
And are those true and accurate representations of them as you remember them that night?
Yes.
Your Honor, may we publish these to the jury?
Is there any objection to E through J?
No objection.
All right, they're admitted.
In photograph E, can you explain to the jury what we see here?
You see two hands, her thigh, and then there's a scratch going down the left thigh.
And is that the front or back of her thigh?
Can I grab it? It's more of like the outside, like outside left part of her thigh.
And in your training and experience, how would someone and their attacker be positioned in order to get an injury like that?
One of multiple ways. The attacker's either on top of somebody and somebody's trying to push or kick them off of them. I mean, there's a bunch of other ways I can't explain.
Could someone be walking away from them and they swipe at them?
Objection.
Sustained.
In your experience, does that look like a fresh scar?
A scar? Or
A fresh cut, I'm sorry.
Yes.
Now I will show you Exhibit F. And could you explain to the jury what you see there?
Again, this would be now her right knee, and it looks like there's some sort of rug burn or scrape on the knee.
And Exhibit G.
Yes,
Could you explain to the jury what you see there?
that's her inside right bicep with a scratch on it, kind of towards the elbow area. It's wrong up on the screen. Yeah, so that's her right hand and the right pinky where there was the scratch on the pinky finger.
And in your training experience,
Correct.
looking at that hand, does that look like a hand that has thrown multiple punches recently?
No.
Can you tell the jury what that is?
Yes. So this is going to be her left hand, and then between the thumb and index finger, there's some sort of rug burn scratch right there as well.
And once more, in your training experience, does that look like a hand that has recently thrown many punches?
No.
And then the last photo I have is eye. Could you please tell the jury what we see there?
Yeah, this is the small scratch on her left shoulder by where like the bra strap or the strap of her tank top was kind of sitting that night. Yep.
Were any of these photos of the thing she told you was there previously?
I don't recall, no.
Okay. Isn't it true that what we just saw in the video, Bonita said that she held her niece down?
Yes.
And isn't it true that you stated you thought that those injuries we just saw were defensive?
Yes.
Aren't those injuries consistent with what could happen if someone's struggling, trying to get you off of them if you're holding them down?
Yes.
Isn't it true that we also saw injury, at least one injury on Bonita's back?
Yes.
Is it possible that Bonita was stricken while her back was to someone?
Objection.
Sustained.
did you tell the other officers that Bonita's wounds were consistent with her story that she told you?
I don't remember mentioning any of that to Officer Jones.
Would you agree that's very important?
Sure.
Is it your training to come to conclusions before you know all of the evidence?
No.
Is it your training to come to initial or partial conclusions before you know all of the evidence?
No.
However, it's your testimony that on that night, after speaking with one person, you came to a partial conclusion.
No, I came to a determination.
Okay, so it's your testimony that on that night, after speaking with one person, you came to a determination that one person should be charged.
Correct.
However, right now, you're not saying that your determination is a partial conclusion, correct?
Can you repeat that?
Of course. So, from the point of view of an officer, the determination that someone should be charged does not qualify as a partial conclusion. Because I asked you about conclusion, you said no,
Correct.
but you made a determination. And so I'm just trying to figure out the difference.
I mean, I don't see a difference. It was just my determination that night.
Okay,
The outcome, conclusion, however you want to call it.
so you did make a conclusion
Correct.
based on speaking to one person.
Correct.
However, you were not trained to do that.
Not always.
Were you trained to ever do that?
I mean, sometimes correct, yes. There's some situations that, yes, that arises.
So your testimony right now under oath that you've been trained to make charging decisions without all the evidence.
Not all the, not, wait, say that again?
So it's your testimony right now under oath that you have been trained in some situations to make charging decisions without all of the evidence.
I mean, there's some situations where I'm only going to get one or two pieces of evidence and still file charges on somebody.
That was not my question, and that's not the situation.
But that's my answer to it.
Okay.
I don't understand.
That's fine. I apologize. How do you determine who's the lead officer?
So that night we had 4 people on, okay? Sergeant Kokenauer obviously is the supervisor of that shift. Officer Jones is one of the senior guys, so he's kind of that float car. And then myself and Officer Warren are the younger guys on the shift or newer guys on the shift. So basically from 1900 hours, so 7 p.m. until 1 a.m., I'll be one zone, and then at 1 a.m. I'll switch to the other zone, and then Officer Warren would be opposite of me, if that makes sense. I'm not,
Absolutely.
okay.
Thank you. So you testified that when you might have asked Benita if she wanted to press charges on your body cam a little bit after it cut off.
Yeah, just in what the prosecution had, yeah,
Okay.
in that video.
One moment, please.
Okay.
Your Honor, can we approach quickly? Officer, I am
Yes.
going to play the remainder of the body cam for you, for us, from where the prosecution left off. I believe it was approximately 8 minutes and 9 seconds. We're gonna play from there until I don't know off the top of my head, but I'll figure it out. And it's gonna be Defense Exhibit K.
It was on mine. So.
You showed up and
Yes.
here we are. Okay, cool. Besides that, I thought you had one
I
on your
don't
arm.
know.
Hey,
I know
what
I
about
got something on my
Is
finger.
this old?
Yeah, that's old. I got this on my finger.
Okay. Can you
This-
can you just put your phone down? I'm gonna get photos of your hands and everything. While I'm doing this, you just get her social and a good phone number. Good. Put your hands out like this. Straight open. Put your hands out like this. Straight open.
What is your social?
Two sep.
What is your social?
Two sep.
Alright, good. Put your arms down. Move this strap just over, just a little bit. You got a scratch on your upper shoulder. Okay. Okay. Oh, you're good. How far does that one come up? How far does that one come up? Okay. Anything on the other leg? Anything on the other leg?
No, just that little scrape. That's what I see. That little scrape.
I'll take a photo of it. I'll take a photo of it. Okay. I mean, what do you? What do you?
I know she hit me in the head, but it wasn't too hard.
Do you know whereabouts?
It wasn't too hard.
Do you know whereabouts? You don't feel any like bumps or like you don't feel
No.
any like like if you like bump your head on a coffee table or something. Like if you like bump your head on a coffee table or something. What about back of the head, neck area? Back of the head, neck area. No. Do you want the squad to check you out, or do you want the squad to check you out, or do you want to press charges against her? Do you want
I don't want to press charges.
against her?
I don't want to press charges. No, I don't. She got enough stuff going on. I don't. She got enough stuff. I hate that it had to even come to this.
Yeah, I get
I hate that it had to even come to this. But I just really want to get out of there. But I just really want to help me get my stuff out of there.
Yeah, I mean, we can
Because I don't
facilitate
trust
all
her.
that.
Because like I said, when I was holding her down, yeah, she attacked me with a pole. But when I was holding her down, she was reaching for something like, bro, I'm about to, ooh, bro, I'm about to,
Okay.
ooh. What is you reaching for?
Okay. I mean, when she was like hitting you or coming at you with the pole, you were in jeopardy of getting severely injured or anything
Yes,
like that.
because
Severely
she
injured
did.
or anything like that.
First of all, like I said, her daughter was in there. Her daughter ran out to the hallway at this time. Her daughter ran out. She didn't care. So I don't know what's going through her head. Honestly, this is her head and back. I don't think she did recently. But she used to try to commit suicide. So if you would do that to yourself, I don't know. So when she got a pole and you waiting for me with a pole, and I'm sorry I'm about to cry because that really hurt that, and I'm sorry I'm about to cry because that really you will really do that?
Right.
You
No,
will
I
really
get
to your auntie?
Right. No, I get
To your auntie?
You said she's what, like 20s?
21.
You said she's what, 20s?
But it's like,
Something like that.
instead of just, if you hear me coming, instead of going into your room and closing the door, because you hear me coming back in, you stood there with a pole and attacked me when I'm coming through the door with your child right there, so you didn't care about nothing. So I don't know what she's capable of to do that while your child right there, and as I'm walking in, you could have just went to your room and went about your day, and I could have got my stuff and I could have left, and I could have got my stuff and I could have left. So I don't know. And again, my mom's in the hospital, so she can't control nothing. She can't do nothing. It's just really be me and her and my daughter.
So if you would get your stuff, your daughter, how old's your daughter?
My daughter is 16.
Okay.
My daughter is 16.
If you would get your stuff tonight and take your daughter with you wherever you go, or take your daughter with you wherever you go, or.
Probably to my sister's house in Bedford.
Okay.
To my sister's house.
Well, you said
Yeah,
you
'cause
might
I
go
don't-
somewhere. That's why. That's the only
Well,
reason.
no, I
You
just
might
know I'm
go
not
somewhere.
staying
That's
here.
why-
I
that's
don't.
why-
Well, no, I don't even care if my daughter stay here and I go in my car. I just can't be here because I want to sleep. I just can't be here because
Yeah,
I know
I mean-
she don't got nowhere to go. Like I said, she from Georgia. She don't got nowhere to go. Like I said, I mean, she can go to a friend house, but.
I mean, here's the thing. Like my sergeant and our other patrolmen are out there with her. She may want to press charges on you for making the threat of pulling a gun. You know what I mean? So I just putting that out there. Putting that out there, and then you take a ride. You know what I mean? And then you take a ride, which I don't want to see happen. So that's why I asked if you wanted to press charges on her or what you wanted to do as far as her coming in.
I had enough stuff going on. Like I said, I had enough stuff going on. She don't. It's enough going on with everybody. It's enough going on with everybody.
Yeah.
Whatever she do, that's on her.
Yeah, I got you.
But me, like I said, she from
Yeah, I
Georgia.
got you.
That's still my niece. She from Georgia.
How old's
that's
her
still
daughter
my
that's
niece.
up there?
One.
How old's her
And
daughter
that's
that's up there?
one. Yeah, so she got too much going on. So she got
Does
too
she
much going
take
on.
care of it by herself? Does she
Yes,
take
her.
care of it by herself?
The dad is in Georgia. The dad
Does she
so
have
it's
any-
just us.
Does she have anybody else up here
Just
besides
us.
you guys? Does she have anybody else up here besides you guys?
She have friends, but I don't know if they like friends, but I don't know if they like consistent. I don't know if they really do anything. I don't know if they
But no,
really
like
do
sibling. But no, like sibling.
anything. No. So, no.
Do you get her phone number? Do you get her phone number? Seven to K1. 7 to K1. Whenever you or Jones is available, if you guys give me a call myself. If you guys give me a call myself.
Like a cramp though. Like a cramp.
Okay. Can we walk over to wherever your car's at and just secure the firearm for right now?
Oh, sure.
Just secure the firearm for right now.
Oh, sure.
Alright.
Oh, I got the trouble.
We're gonna fast forward from here till 1910. The intervening 5 minutes, they're just walking to get her gun. He tells them the serial number.
Can I read object?
Oh, fine, we can play the whole thing.
Well, come on up.
So we're gonna forward to 1910, fast forward to 1910.
Where were you staying at before you moved in here? Oh,
the
the
townhomes.
townhomes, that's
Yeah.
right.
In the process of getting a house built, so I just in the process of getting
All
a house
right.
built to my mom.
Where are you building a house at?
Sheffield.
Where are you building a house at?
Sheffield.
What's that? That's right next to Akron, isn't it?
Avon.
Or Avon, isn't it?
Avon.
There's a different lake out there. Portage Lake. Lake out there. Portage Lake.
Yeah. Real nice. Yeah.
How'd you find that? You work out that way, or?
No.
Oh.
Online it was different. Like it's from Brian. Online it was different. Like it's from Brian. Website.
Oh, nice.
Initially, I was looking at Illyria, but then they built different
What's
places.
taking you all the way out there? That's like the west
I
side.
like
All the way out
that's
there.
what
That's like
because I like before I moved up here I was in Harmony. Before
Ah,
I moved up here,
got it,
before
okay.
that I was in Broadview Heights. I like
okay.
that I was in Broadview Heights. I like that.
You don't like the east side.
No, not really.
I got you.
No, not really.
I got you.
Yeah.
What do you do for work?
I work at University
What do you do for work?
I'm an operations coordinator. And then that's the thing with, like I said, my niece. And then that's the thing with, I hired her since she moved here. Hired her to go through something like this. To go through something like this.
Which hospital? Downtown?
Main campus.
Which hospital? Downtown?
Main campus. Main campus.
Do you want to fill out any statement or anything? Do you want to fill out any statement or anything? On paper.
Not really.
Just like put on paper.
Not really.
How long you been at UH? How long you
It'll
been
be
at
10
UH?
years in November.
Eight.
It'll be 10 years
Good for
in
you.
November.
Good for you.
Absolutely. Absolutely.
So what's the like day to day on operations coordinator? What's the like day to day on operations coordinator?
Well,
Are you like an RN and stuff?
no.
or
So
RN and
honestly,
stuff,
no.
or-
So honestly, the whole new department. So pretty much right now, what I do is I create cost-effective non-clinical programs for like the COO, whatever, to assist clinical areas. Like right now, I just clinical areas like right now, I just created like a lab here to just transport lab specimens, to deliver meds to patients, ambassador positions, the ED, which they just assist nurse, doctors, or any type of patients, visitation pass, police.
That's pretty cool.
Yeah, that's pretty cool. So initially, I think that started like when COVID started, they just started, and then every time they made up something, it was like, I want you to do it. I want you to do it.
They had all that COVID money. They're like, hey, we need jobs here.
Exactly.
Yeah. Like, hey,
Do you
we
mind
need
if I call
jobs
my
here.
daughter?
Yeah, you're fine.
Do you mind if I
Yeah,
call my daughter?
you're fine. Yeah, you're fine. That's funny.
Yeah, we're gonna do this. Could you do it? I'm like,
How do you like it?
I love it.
Actually, how do you like it?
I love it.
So what do you
Every
work like
type
9
of
to
project.
5 or? So what do you work like 9 to 5 or?
Really?
Really?
Like I said, I
Really?
went to Hey You Okay. Like I said, I went to Hey You Okay. How are you at? How are you at? Alrighty, just checking on you. Alrighty, just checking on you. Would you call me? Would you call me? Alright. Is the police still up there? Is the police still up there? No, they're not.
Maybe they're coming down.
Oh, okay.
Maybe they're
All right.
coming down.
Oh, okay. All right. Like I said, I went to work at 9 last night, and I didn't get off till 2 p.m. today. So it's like I worked today.
See, I would have thought
Different
you.
time. And then I was going back at
See, I would have thought you.
6 a.m.
Yeah. See, I thought your job would have been more like. See, I thought your job would have been more like.
No,
Okay. See, I thought your job would have been more the like 8 to 4, 9 to 5. You know, just in the office and stuff like that.
to be honest, that's my regular hours.
Yeah.
That's my regular hours. I can't work the regular hours. I pick up anytime, all around.
That's cool that they like don't care. You
Right,
know,
no,
you
no,
just like
because
you
it's a
don't
new
care.
department.
You know,
Right,
yeah.
everybody that's in the department right now, everybody that's in the department right now, I still am hiring, I still have to train, orientate,
Yeah, sure.
still process control,
So you're the one that basically is the boss, and you basically is the CEO,
Yes.
and yeah, I got you. You're the CEO.
Yeah,
and
CEO,
I got you.
my boss, do the work, my boss, do the work.
Shamaya is your niece.
Yes,
Oh, Shamaya is your niece.
yes.
How long has your mom been in the hospital, if you don't mind me asking? How long has your mom been in the hospital, if you don't mind me asking? Oh, really?
Yes, she just had a
Oh,
stroke.
really?
Yes, she just had a stroke. Yes, yesterday morning.
Give me
Yes.
just a second.
Yesterday morning.
Give me just a second.
based off the witness and the girl up there. So it sounds like they. So it sounds like they, at least. The one up there lives there with grandma. Grandma had a stroke, blah, blah, blah. They got into shit about some keys or something, some petty bullshit. They started everything. But what'd he say?
That's a guess.
What'd he say?
That's a guess.
By cop. She's gonna fill out statements and paperwork. So she kept like pushing and pushing. Came in there in the bedroom, like started choking her out and shit. Like eventually punching her in the side of the face. She's got like small like scratches, whatever. This kept going on and on. Then that ended. Then she went downstairs because she said she wanted her car seat out of the car or some shit. She came up. It started back up again. She was choking her out, punching her in the face while she had the kid in her hand. Then the kid was on the ground. She was on the ground, like the pipe or whatever, to defend herself. And that she like grabbed it midair. She like threw it down midair. Grabbed the purple or pink, I forget exactly what she said, gun out of her purse. Started waving it around like I'm gonna fucking shoot you. I'm gonna fucking shoot you. Even that's funny. Her daughter, like kind of like agreed with that. She said like this happened in the hallway.
That's funny because the gun is in purple, like soft case holster, like a soft case. That's why I secured it. I was like, hey, can we just grab your gun?
What color is the gun?
It's a black handle.
But she described purple. She said purple or pink. I'd have to double check.
She said purple soft case, like holster, like outweighs with the holster.
So she said that literally her daughter, like the 1-year-old, was like standing right there while she was waving, like standing right there while she was shooting. Like over and over. So yeah.
Take her for
So yeah. But so she needs to go.
Shemaya Frierson showing a what looks like a Georgia address. 21 looks like a Georgia address. 21.
I copy. All right. Well, let's
Agnes.
DV. It's technically your aunt. DV.
Yeah.
It's technically your aunt.
Do me a favor, go ahead and take your purse off for me.
Chief person in charge.
Spin around, face the car. Hands behind your back, palms together like you're praying to Jesus. Those okay? Too tight? Those okay? Too tight?
Is Shemaya saying?
She is.
Yeah.
Can my mom work somewhere where she has to give somebody her key? Like I was supposed to be the one to drop off. But it's in my purse.
Yeah, I'll give it to her and give it to her. Is that what you want?
Yeah.
Yeah, to her.
It's multi. Yeah. I just gotta redo this. It's multi. I gotta pass it.
Oh, you're good.
So I'm a police officer. Your rights remain silent. Anything you say can will be used against you. You have the right to advise a lawyer before being questioned and advise a lawyer while you're being questioned. You cannot afford to hire a lawyer. One will be appointed to hire a lawyer. One will be appointed.
It's the key fob.
No, it's just a single key.
Decide at any time, exercise your right, not at any time, exercise these things, do not answer any questions, make these things.
Yes. Yep.
I'm just gonna put it in my back pocket.
Yep.
Alright, we're gonna walk up to the very first cruise round. Have you have a seat back there? I'll put your stuff in the back with you.
The remainder of the video is just her in the back of the car. So, officer, it's your testimony that you have made the decision that Benita should have been charged at some point while you were speaking with her, correct?
Yes.
And you heard yourself on the video tell Benita that she might press charges for you making the threat, correct?
Correct.
And you also heard yourself tell her, I don't want to see that happen though, correct?
Correct?
When you were speaking with the other officer, you heard him tell you the allegations against Benita, correct?
Yes.
The allegations that she had strangled her niece, correct?
Well, I had heard, or that part, yes, yeah.
After he finished telling you what happened, the only response you gave about what you learned was, that's funny because the gun is in a purple holster, correct?
Yes.
Which means you did not give any details about what Benita told you, correct?
Correct?
So nothing she said that happened was considered in whether or not she was the primary aggressor, correct?
No.
Was considered by the other officers, correct?
By Officer Jones, or
Officer Jones and your sergeant?
I didn't talk to my sergeant, just Officer Jones. But no.
So it was your testimony that it's common for officers who are on scene to split up and talk to witnesses, correct?
Yes.
And then come back together to make a decision about what to do, correct?
Yes.
And that's what you did in this situation, correct?
I didn't hear the last part.
And that's what you did in this situation, correct?
Yes.
Okay. So, even though you were the main officer, the lead officer, you did not share what you learned with anyone, correct?
Just Officer Warren, but Officer Jones and Coconut, no.
And Officer Jones was the one who interviewed Shemaya, correct?
Yes.
Would you say, is your testimony that the two people who interviewed the main witnesses in this case never spoke about it before making charges, correct?
Objection.
I'm not, can you restate that? I'm not sure what that
Yes.
question was.
Is it your testimony that the two officers who spoke with, who you determined were the alleged victim and defendant, never spoke with each other before charging someone?
We did speak together because she was not charged till she was brought back to our jail. And then that's also where Sergeant Coconut met us as well in the jail, and we talked to him as well. And then she was issued charges.
Was it your testimony that you decided she should be charged while you were talking to her, correct?
Objection.
Overruled.
Yes.
And was it your earlier testimony that you decided she should be charged after talking with the officer we just saw you talk to on the video, correct?
No.
Okay,
Wait, restate that?
I'll withdraw that question.
Okay.
Officer, you wrote a report based on what you did for this, correct?
Yes.
And do you remember what you wrote in that report?
Most of it. I'm not word for word, but
Right. Did you have a chance to review it before coming here?
yes.
And is it your practice at Willoughby Hills to add supplements to reports if you need to?
Yes.
Did you include anything about Bonita's demeanor or her claim of self-defense in your report?
I'd have to read through it. I'm not sure.
If I showed you a copy of your report, would it refresh your recollection?
Yeah.
Your Honor, may I show the officer a copy of his report? It's
Yes.
an unmarked full version.
Thank you.
Just look up when you're done.
Okay. Okay. No.
So based on your review of this, is your recollection refreshed?
Mm-hmm.
But did you include in your report Ms. Fryer's claim of self-defense?
No.
No further questions.
Any redirect?
Thank you, Your Honor. When you indicated that you were the lead officer, that has to do with it being in your zone, correct?
Yes.
Okay, so you're the lead officer, you get the information, and you're speaking with Benita Fryer, and then the information that you need to make a complete determination of what's gonna happen would come from officers who spoke with the other individuals in the apartment.
Yes.
So is it fair to say your initial inclination, whatever we wanted to word it, was that Benita Fryer should be charged?
Correct.
Did you hold off on making a final determination or conclusion until you had spoken with an officer who had information about the witnesses in the apartment?
Witness and victim, yes.
So since you're the lead officer, you're the one who needs to know what everybody said, whereas the other officers don't necessarily need to know every detail.
That's correct.
Because once you take all of their information in, you can make the complete determination of what are appropriate charges.
Correct.
So on scene, Patrolman Jones came to you, told you the information he got from Shemaiah and the information he got from Sergeant Kokenauer.
Correct. And then I take that back with me to the station. I basically am the one that will handle all the booking into our computer system and stuff like that, while I give a list or whatever of charges for any individual to either the supervisor or another patrolman, so that way they're downstairs typing while I'm doing all the booking, so we can get everything done quicker and back out on the road. Correct, yes.
And back at the station, Sergeant Kokenauer came and gave you additional information regarding a strangulation charge.
That's correct.
So then, taking all of the information together so that you have all the information, the one making that decision, you're able to do so.
Correct.
No further questions.
Any recross?
There's nothing in your report about the additional information you were given about the strangulation, is there?
No.
Nothing further.
All right, you may step down.
Thank you.
All right, ladies and gentlemen, I'll let you go for lunch. Remember not to discuss the case with anybody. No outside information of any sort, and don't come to a conclusion the case is submitted to you. We'll be back and start again about 10 minutes of 1. All right, I presume the purpose of the lab testimony is the operability of the firearm, is that correct?
Yes, Your Honor.
Is there any dispute?
We'll stipulate.
Stipulate to that.
You stipulate, do you stipulate to the operability of the firearm?
And also the, one moment, sorry. Thank you. We would also, we're going to have her enter the firearm State's Exhibit 6 into evidence, so if we have stipulation to operability as well as a stipulation to the admissibility of State's Exhibit 6.
Okay.
We can't stipulate to that.
We can stipulate to the operability of the
All right,
firearm.
we'll just have the testimony then.
Edgell, and it's Edgell.
And where are you currently employed?
I work at the Lake County Crime Lab in Painesville, Ohio.
And how long have you been employed at the crime lab?
I started working there in 2021.
And what is your position there?
I'm a forensic analyst.
Would you outline your education and background that qualified you for that position?
So I have a bachelor's of applied science in forensic science with a minor in chemistry from Youngstown State University in Youngstown, Ohio. And I have a master's of forensic science in friction ridge analysis from George Washington University in Washington, D.C.
And were you employed anywhere prior to the Lake County Crime Lab in the field of forensic analyst?
Yes, I worked for the Department of Public Safety, Division of Criminal Investigations, Criminalistics Laboratory in Ankeny, Iowa, which is the state lab for the state of Iowa, for about 2 years.
Are you a member of any professional organizations?
I belong to the Association of Firearm and Tool Mark Examiners, which is AFTE for short. I also am a lifetime member of the IAI, which is the International Association for Identification, and I also belong to a regional branch of that, which is the Ohio Identification Officers Association.
Have you testified previously?
Yes, I have.
And how often and in what courts have you testified?
I've testified approximately 4 times in common pleas for Lake County and once in Willoughby Municipal Court.
And generally, what is the Lake County Crime Lab?
It's a full-service laboratory that provides testing services in specific sections as it pertains to forensic science and what agencies submit to us as evidence.
And what types of disciplines are housed at the Lake County Crime Lab?
So we have a couple different disciplines. One of them is DNA analysts and their analysis. We also have a trace evidence section. We have a toxicology and drug chemistry section, as well as a latent print and a firearm section.
Is the Lake County Crime Lab an accredited lab?
It is.
What does that mean?
So an accredited laboratory for us is that we meet certain specifications by a governing body. Our governing body is testing for forensic testing. The overarching body that we are accredited by is ANAB, which is just it's for the ANSI National Accreditation Board, which is just make sure that all of the procedures that we're doing follow an ISO standard. So that's like an international standard for forensic testing and forensic calibration testing.
What is the process for obtaining and continuing that accreditation for the lab?
So every 4 years, we have the body will send an individual to come in and assess us, which means they're going to look at all of our procedures and the way that we conduct business and make sure that it aligns with the outcomes that they expect and is generally accepted for the field. So that's every 4 years. Every 2 years, we have another visit where they're doing another assessment, but not necessarily in the laboratory. And then every year, we're doing an internal audit to make sure that what we're putting out meets those high standards from the ISO accreditation.
Can you explain for the jury the process that occurs when evidence is submitted to the lab from a police department?
The agency will bring to the laboratory the evidence items that they'd like to submit for a case. They are then let into our lobby, which they then talk to our evidence technicians. When they bring in the cases, they're going to tell us this is the type of testing we want on this item. And the item is given an overarching case number, as well as an individual item number. That individual item number is tracked using a barcode, which is placed on the outer packaging of that item. Every item is checked to make sure that the seals are intact and that it can't be opened or tampered with, or it appears to be in a very secure condition. As that's coming in, it's being evaluated by both the agency itself and by our evidence technicians. When the evidence technicians will not accept anything that appears to have been not sealed or has been tampered with, they won't accept it into the laboratory. So when the item of evidence is brought in, it's given that specialized barcode, which is then tracked to the laboratory. It's checked into the laboratory to the evidence technician, and then is stored in our secure evidence room until it's time for processing.
And is an evidence submission sheet prepared?
It is, yes.
When evidence is brought in, where is it stored, and where do you go to retrieve it?
So when a case is assigned to a specific area or a specific section of the laboratory, we receive notification via a colored folder. And when we have that colored folder, we're allowed to, we know that it's upcoming and what's the next one on our queue. So when we're ready to work that case, we will go to our secure evidence storage, which is in an evidence room and behind an evidence cage. The door to the evidence room is keypad entry only with the secure access, as well as the evidence cage itself is also securely only available for secure access because it has a padlock on the outside of it.
And what section of the crime lab do you work?
So I am authorized to perform testing in the latent print section as well as the firearms section, specifically on operability of firearms.
And was evidence submitted for testing in the case you're subpoenaed here for today?
Yes, it was.
And was that evidence submitted in the manner that you've just described?
Yes, it was.
Your Honor, could I approach the witness?
Yep.
Handing you what's been marked State's Exhibit 7. What is that?
This is a copy of the evidence submission form that was submitted to the laboratory for this case.
Does it have the specific barcode and number that you've described on the top of that?
Yes, so at the top of this is a copy of the barcode that would be put on. This number at the top here is the case number in which the evidence that's submitted is given. So this is the overarching case number. And then this item would have a second barcode, which would be tied to this number, but have a specific item number associated with it.
What does that describe was submitted to the lab for testing in this case?
So this says that item 1 was submitted, and it is a Smith & Wesson M&P 9mm handgun with loaded magazine and 7-round 9mm ammo.
Judge, may I approach again?
Yep.
Show you what's been marked as State's Exhibit 6. You aware of what that is?
Yes, I am.
How do you know?
So here, marked here is a barcode. It has the case number and the specific item number, as well as my initials when I obtained it from the evidence room and when I started working on it.
Are there any other markings that you have placed on the box that you could identify?
Yes, I also sealed this package as well, and so there's, along other people's sealed signatures, I have my signature, my initials on the barcode as well as the date that I sealed it.
And so how you've described it, would it be fair to say that the barcode on the submission sheet would match up to any piece of evidence that you are testing?
So it would be tracked back to the case number in which those evidence is. So this is for the case number of this one, but the specific item of this one. So it's barcoded to that specific case. They are the same case number.
So this is the firearm that you tested in this case?
Yes, it is.
Go ahead.
Yes. It's very secure.
What is contained inside that box?
I'm just gonna grab some gloves really quick. Okay. So in this box, we have a purple holster with a black metal clip, some envelopes of some swabs, and a container that has ammunition in it, as well as a magazine that's secured to the base and a firearm here. So I'll try and show it. This is empty and unloaded. It's verified by this lock here, and this is the firearm that was described on the sheet, as well as the one that I examined.
Just for the record, is there a gun lock in that firearm?
There is, yes.
When this firearm was submitted by the Willoughby Hills Police Department, what was your first step in testing it?
So when I begin testing for a firearm, I will go and retrieve it from our secure evidence room and take it down to our range. I'm going to check and make sure that all the seals are intact and that it corresponds to the correct item number, which I'm supposed to be working for the specific case. After I do that, I open the box and take a documentation photo to show this is exactly what I received in this case and as it appears in the box as I received it. I will then swab the firearm for DNA, put that into a separate envelope, and then I will proceed to do some bench testing and some safety tests. During that time, I'm also assessing to make sure that the firearm is empty, unloaded, appears to be in good condition, it doesn't appear to be broken in any way, that the wear isn't excessive, to count the number of cartridges that are submitted with it, if there are any, the number of magazines, and just perform some general function testings without any ammunition present.
So after that initial testing, you do additional analysis of the firearm?
So that initial testing is going to cover all the functionality parts of it, as well as just like an overall look, and then I will also do some test firing afterwards.
Was test firing done in this case?
It was, yes.
What was the process of that?
So after I confirmed through various tests, including a pencil test and some other safety checks, I will then take it next door to our range, which is indoor, and shoot it into our bullet recovery system, which is a water tank. I will use typically a combination of submitted ammo and laboratory ammo to make sure that it will function. And all we're doing for that test firing is just showing that this firearm is able to fire and propel an object via the force of combustion.
And you photograph items before you test them?
I do, yes.
Your Honor, may I approach the witness?
I'm going to show you what's been marked as State's Exhibit 4. Do you recognize that?
Yes, I do.
What is it?
So this is a photograph of what I received in this case before I performed any of the testing. And I know that I took this photo because my marks are at the bottom of the box here, as well as the scale. So this is just to establish exactly what I received in this case prior to any removal and testing.
So that photo is fair and accurate of what you saw when you opened the box and photographed this?
Yes, that's correct.
When you're finished with the analysis that you've described, what do you do with the item?
I then return the item to its packaging and secure it to the box safely, to the bottom of the box, and I label all the items of evidence that I received with the case number and item number that I assigned them during analysis. I secure it to the bottom of the box and then seal the package with evidence tape and label the outside of it to ensure that it's all contained, and then I submit it back to the evidence cage and notify that the agent, write a report and notify the agency that it's completed.
So you stated when you're finished with your analysis, you prepare a report?
I do, yes.
Judge, may I approach the witness?
And you wish to be marked for identification as State's Exhibit 8. What is that?
This is a copy of my report for this case.
Is that a fair and accurate copy of your firearms analysis report with regards to this case?
Yes, besides the blacked out parts, but yes.
And would it contain the identifying information that connects items throughout the lab?
Yes.
What would that be?
So it has the case number, which is marked at the top here in bold, with the 24-000822, report number 1, which is the 001, and that's what it's regards to. And then it has the different items of evidence that were tested for this report, which includes item 1, which is the firearm.
Were you able to come to a conclusion about the operability of the firearm you tested in this case?
Yes, this is an operable firearm that functions normally.
Is this firearm capable of causing death?
Yes.
Your Honor, could I have just one moment?
Yep.
Your Honor, could we approach for just a moment? No further questions.
All right, cross-examination?
No motions.
Okay, you may step down.
Thank you.
State's next witness?
Your Honor, the state would rest at this time pending the admission of any exhibits.
All right, ladies and gentlemen, the state has rested, meaning they have presented all the evidence they intend to present. The next phase of the case would be the defense, if they choose to put on a defense. At this point, I'm going to send you back to the jury room because we have some business to take care of out of your hearing. Remember not to discuss the case, don't try to find out any information, don't come to any conclusions.
All right.
All right. As to the exhibits, 1, 2A through 2F, 3A through 3I, 4 and 5 have already been admitted. Do you seek to admit other?
Your Honor, we would seek to admit Exhibit 6, which is the firearm, magazine, ammunition, and holster.
All right, 6 will be admitted.
The only other question we had, Your Honor, those are all of our exhibits. I just wanted to clarify something when defense was entering Exhibit K for Patrolman Muir's, the completion of his video. When I had not objected, it was for the completion from 809 forward. So I just wanted to clarify that because there was a section that was redacted from the beginning part that would not be admissible. So I didn't want a full one to go back that has that section in.
Which part?
We'll discuss that when we get to their
Okay.
exhibits, okay?
Oh, no, we don't have any objections to it there.
All right, well, we'll talk about that when we get to the end of your stuff. What do you got at this point, Mr. Nicholson?
For exhibits?
No.
Oh, Your Honor, at this time, we would like to put our Rule 29 on the record, and we don't have any witnesses.
All right, do your Rule 29 motion then.
Your Honor, at this time, defense counsel would ask the court to propose to the court, and orally file a Rule 29 motion for judgment of acquittal. Your Honor, the standard, even if held to the standard in the most favorable light to the state, reasonable minds could not come to determination to prove every single element beyond a reasonable doubt. We don't believe that the state, even in the most favorable light to them, we don't believe, and we submit to this honorable court, that they did not prove count 1, all the elements beyond a reasonable doubt. They did not satisfy their burden pursuant to, on count 2, strangulation, beyond a reasonable doubt. We don't believe that they satisfied their burden on count 3, domestic violence, beyond a reasonable doubt. As to count 4, we don't believe that they established their burden of proof beyond a reasonable doubt. Those counts, Your Honor, because we don't believe that they proved serious physical harm or the attempt to cause serious physical harm. Be that as it may, they cannot prove the elements. You have to prove those elements. Therefore, they have not met their burden on the first 4 counts. With regard to aggravated menacing, Your Honor, we don't believe that the state of Ohio, even in the most light favorable to the state of Ohio, that they prove their guilt beyond reasonable doubt, because it's argumentative as to what there's reasonable minds could come to conclusion that they did. So, Your Honor, for those reasons that I just placed on the record, we would ask this honorable court to grant our Rule 29 judgment of acquittal on the charges.
All right. Hang on one second. Scutts?
Thank you, Your Honor. As this court is aware, obviously, at this stage, it's not beyond a reasonable doubt, but in the evidence most favorable to the state. We do feel that we have presented more than sufficient evidence to go forward on all 5 counts. Count 1 requires creating a substantial risk of serious physical harm. It doesn't require that there be serious physical harm. There was statements about concerns of losing consciousness, as well as the fact that whenever anybody impedes the airway, has trouble breathing, and is being held down for a period of time, that there is the risk, a substantial risk, that you could lose consciousness, which is serious physical harm. Obviously, we're not saying that that occurred here, but they did create a substantial risk of serious physical harm to Shamaya, who was the victim in this case. In count 2, it's knowingly cause or create a substantial risk of physical harm. So 1, we do have evidence of physical harm based on the testimony of the victim as well as others regarding the swelling and discoloration and the cut on the right side of her neck that was shown in some of the exhibits, as well as there doesn't actually have to be physical harm as long as there's a substantial risk of physical harm, and that goes to my further argument that a risk of serious physical harm would cover that. And Shamaya Frierson is a family or household member. I don't believe that's been in dispute, but that she is the niece of the defendant, Benita Fryer, that her father is Benita's brother. So there would be a blood relationship. Regarding counts 3 and 4, cause or attempt to cause physical harm, again, there's evidence submitted of injuries on her face, on her legs, the groin area, injuries that were sustained both in the bedroom location as well as out in the living room. So we do feel that we have more than sufficient evidence to go forward that there was physical harm, even if there was a belief that there was an attempt to cause physical harm by the evidence that has been presented. And as for the aggravated menacing, again, that would be that the actions of Benita Fryer would cause Shamaya Frierson to believe that she would cause serious physical harm to the person or person of Shamaya Frierson or a member of her immediate family. And obviously, she was very concerned that she was going to be injured and when the gun was pulled out, as case law has indicated, pointing a gun at an individual is sufficient for aggravated menacing, and the belief that she could shoot her to the point that she was closing the door, calling the police, grabbing her daughter. Obviously, the firearm is capable of death and could have caused serious physical harm. Based on all of that, we do feel that all 5 counts should go to the jury and that Rule 29 should be denied.
All right, based on the testimony and the applicable standard, I'll deny the motion for acquittal. Ms. Fryer, do you understand that you have the right to testify in this case if you want to?
Yes.
You also understand you have the constitutional right to not testify if you do not want to?
Yes.
And if you decide not to testify, nobody could comment upon that during this trial. Do you understand that?
Yes.
All right, and is it your decision, regardless of what your counsel's recommendation is, that you do not want to testify in this case?
Yes.
Okay. All right, so what we'll do, and you have nobody else to present, correct?
No, Your Honor, I just gotta put some stuff on the record.
All right, so we have E, F, G, H, I, J, and K have been admitted, and then with regard to K, you want to go over that again, Ms. Cutts?
Yes, Your Honor. When it was presented, it was indicated that they would be playing the body cam from 8:09 to the end. That's what I did not object to. Our recording goes to approximately 8:12. The first 30 seconds of the officer just arriving were not put on there. But there was a section from 4:24 to 4:27 that was redacted out of what we played because it referred to an accident and allegations of drunk driving against Shemaya Frierson, which would not have come in, so that was redacted.
Where on the
4:24 to 4:27.
So 3 seconds?
Basically, yes.
Okay.
So that was removed from State's Exhibit, I believe he's 5.
Okay.
Yes, so we don't have an issue with from the 8:09 on, which is what was verbalized in the courtroom, but I wanted to clarify that that wouldn't be the beginning part.
Your Honor, they introduced a video on direct examination. And it was just 8 minutes of the video, Your Honor. We think that the jury should have the entire video. They opened the door, we heard testimony.
Where did the portion of your video is what to what on the body cam?
From 32 seconds, so we started it at 33 seconds, and then we took out the 4:24 to 4:27, and
Okay.
it ended at 8:12.
Okay. All right, so you want 4:24 to 4:27 in?
I want the whole thing in. Yes, Your Honor, yes.
Okay.
I'm sorry.
So I'm not going to allow 4:24 to 4:27 in because it's not relevant.
Okay.
So you can have the whole thing in, but
Those of you who
the only portion of that body cam you have is those 7-8 minutes, right?
Correct.
In what format is the entire body cam? How are they going to play that if they want to watch it in the jury room?
It is on laptop. We have not since we didn't admit that, we didn't put that onto disk.
Okay.
Obviously, it can be put onto a disk,
Okay.
but it has not been done because it was not what we were doing.
Your Honor, would it be sufficient for it to be on the flash drive? I have it on there.
I don't care, but 4:24 to 4:27 have to be.
We can do that.
Okay.
You can remove it from your flash drive?
You should remove it because you want to reject it, right?
No, listen, I'm not gonna argue about,
I'm not
if you wanna present K, okay, you can present K. It's admitted, but 4:24 to 4:27 are not gonna be on there,
Okay.
okay? So,
Then I can't admit what I have on this.
okay, so how do we get something prepared that redacts 4:24 to 4:27 that doesn't happen, that is gonna happen so that they can have it when they need it this afternoon?
Your Honor, if the court would like, I can ask our investigators to start it where ours ended just to the end, and then
No,
they
the
would-
whole thing is gonna come in. The whole thing.
No, I understand. I just meant because we have the beginning, and then theirs would have the remainder,
Okay, can they do the whole thing,
and just take those out.
redacting 424 to 427, and we'll call it Exhibit K?
We can request that.
Okay,
That's fine, Your Honor.
okay, problem solved. So now we're gonna come back in, I'm gonna bring them back in. I'll ask you if you have anything to present. You can rest, subject to the admission of the exhibits, just to say that, but they're already admitted, okay?
Yes, Your Honor.
And I'll send them out again. You can put on the record whatever you want to put on the record, and we'll look at those, the verdict forms, make sure those are all set, and we're going to do closing,
Yes, Your Honor.
okay?
Yes,
And
Your
we
Honor.
have a moment where I can call over to our investigators to request.
Yes, we'll give you enough time when we send them back out that you can do that,
Okay.
okay? Have a seat. All right, does the defense have any witnesses to present?
No, Your Honor, the defense rests at this time, subject to the admission of our exhibits, Your Honor. Thank you.
Okay, the defense is rested, that means you have all the evidence that you're gonna have in this case. So you're gonna get up again, you're gonna go back to the jury room, because there's a few more things we have to do. And when we come back, then we'll have the closing arguments, and after the instructions, what I do is a bulk of the instructions, jury instructions, followed by closing arguments, and then some final instructions, and then the alternate will be identified, and deliberations will begin. So you're probably gonna have upwards of 25 minutes or a half hour, okay? So I'll see you in a little bit. Why don't you go make that call now, and then we'll come back and talk about the other stuff, okay?
on the video of Miss Fryer talking about, explaining to Amir about how she was attacked throughout the whole incident. So, Your Honor, we believe that, or we submit that that testimony and that evidence that was presented to this honorable court and to the jury warrant a self-defense instruction. Thank you.
Anything you want to put on the record, Ms. Cutts?
Yes, thank you, Your Honor. When Detective Muir testified to defensive wounds, he was specific and said that somebody was defending themselves against Benita Fryer, not that Benita Fryer was defending herself, that somebody else was defending, and she got these injuries because somebody that she went after responded back, and even went into the part testimony where it would be consistent with somebody, with Benita being on top of somebody and somebody struggling underneath her, and that's how those injuries came. As for the kick that only came from the defendant, there is other testimony that it does not have that, and just simply kicking somebody as they walk out of the door does not give you the right to self-defense in and of itself. And
Okay.
obviously the notice was insufficient.
All right, there was, a notice pursuant to Criminal Rule 12.2 filed on 4/10/25, a response by the state, judgment entry issued 4/16, which indicated that based on the violation of Criminal Rule 12.2, that self-defense would not be considered, so there would be no instruction on self-defense. Is there any issue with regard to the verdict forms?
Not from the state.
From the defense?
Say that one more time.
From the defense, the verdict forms?
Well, Your Honor, again, I would object to the court's ruling because...
I know you objected, and you put on the record the reason for your objection, and I made my ruling. Now, the verdict form, anything on with regard to the verdict form?
We don't have anything.
All right, we'll begin at 1 o'clock or 2 o'clock.
check?
It's already
Yeah,
checked.
yeah,
It's
we
done.
did, we did.
This is it then?
Yep, it's
You're
done.
good? I thought you were still doing it. Okay, that's fine.
See you, please. All right, as I told you before we broke, the next phase of the trial is the jury instructions, closing arguments, followed by the final instructions. And as you can see, you've been given a copy of these instructions, and you could either read along or not read along. It's up to you. I just found it's easier, rather than being talked at, to actually read along if you if you get more out of it that way. So I'll give you the bulk of the instructions, followed by closing arguments, and then the closing instructions. Ladies and gentlemen, you heard the evidence. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law, nor to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant she has been charged with offenses. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charges and puts in issue all the essential elements of each offense. The defendant is presumed innocent until her guilt is established beyond a reasonable doubt. For each offense charged in the indictment, the defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of that offense. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If, after a full and impartial consideration of all the evidence, you are firmly convinced of the truth of the charge, the state has proved its case beyond a reasonable doubt, and you must find the defendant guilty of that charge. If you are not firmly convinced of the truth of the charge, you must find the defendant not guilty of that charge. Evidence is all the testimony received from the witnesses, the exhibits admitted during trial, and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial or both. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. Direct evidence is a testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. If you awake in the morning and see the ground is covered with snow, that is circumstantial evidence that it snowed earlier. If you see human footprints in the sand, that is circumstantial evidence that someone had walked there. To infer or to make an inference is to reach a reasonable conclusion of fact which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight and probative value. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Some exhibits may appear to have been deleted, redacted, or omitted. There is nothing improper in any deletions, redactions, or omitted material, and no one has tampered improperly with such evidence without the knowledge of the state, the defense, and the court. In fact, such deletions, redactions, or omission have been done at the request and agreement of the parties. Any material that has been deleted, redacted, or omitted is irrelevant to your determination of the issues in this case. You are to infer nothing by what you think may be deleted, redacted, or omitted. Do not conjecture or speculate on what was not presented to you in the exhibits. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may use the test of truthfulness which you use in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the accuracy of the witness's memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. By using these tests, you may assign to each witness's testimony such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express her opinion because of her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In determining its weight, you may take into consideration her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. It is not necessary that the defendant take the witness stand in her own defense. She has a constitutional right not to testify. The fact that she did not testify must not be considered for any purpose. Police officers that testified in this case, you are not to give any greater or lesser weight to their testimony based solely on the fact that they are police officers. In count one, the defendant is charged with strangulation. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 11th day of August, 2024, and in Lake County, Ohio, the defendant knowingly created a substantial risk of serious physical harm to another by means of strangulation or suffocation. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result. A person has knowledge of the circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. Serious physical harm to persons means any of the following. A, any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. B, any physical harm that carries a substantial risk of death. C, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. D, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. E, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. Strangulation or suffocation means any act that impedes the normal breathing or circulation of the blood by applying pressure to the throat or neck or by covering the nose and mouth. Substantial risk means a strong possibility as contrasted with a remote or even significant possibility that a certain result may occur or that certain circumstances may exist. In count two, the defendant is charged with strangulation. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 11th day of August, 2024, and in Lake County, Ohio, the defendant knowingly caused or created a substantial risk of physical harm to another by means of strangulation or suffocation. Cause is an act that in a natural and continuous sequence directly produces the physical harm to person and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. Physical harm to persons means any injury, illness, or other physiological impairment regardless of its gravity or duration. The terms knowingly, substantial risk, and strangulation or suffocation all have the same meanings as above. If your verdict is guilty, you will separately decide whether the state has proved beyond a reasonable doubt that the alleged victim was a family or household member of the defendant. If you find the defendant not guilty of strangulation, you will not consider whether the alleged victim was a family or household member of the defendant. Family or household member includes any person related by consanguinity or affinity to the offender and who is residing or has resided with the offender. Reside means to live in a place on an ongoing basis. Residing is something more permanent in nature than just periodic visits, even if those visits are overnight or last several days. Consanguinity means a blood relationship. Affinity means relationship by marriage. In count 3, the defendant is charged with domestic violence. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 11th day of August 2024 and in Lake County, Ohio, the defendant knowingly caused or attempted to cause physical harm to a family or household member. The terms knowingly, caused, physical harm, family or household member, reside, consanguinity, and affinity have the same meanings as above. An attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. In count 4, the defendant is charged with domestic violence. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 11th day of August 2024 and in Lake County, Ohio, the defendant knowingly caused or attempted to cause physical harm to a family or household member. The terms knowingly, caused, attempt, physical harm, family or household member, reside, consanguinity, and affinity have the same meanings as above. In count 5, the defendant is charged with aggravated menacing. Before you can find the defendant guilty of aggravated menacing, you must find beyond a reasonable doubt that on or about the 11th day of August 2024 and in Lake County, Ohio, the defendant knowingly caused Shemaiah Frierson to believe that the defendant will cause serious physical harm to Shemaiah Frierson or to a member of her immediate family. Knowingly caused serious physical harm and substantial risk have the same meanings above. Immediate family means a person's spouse residing in the person's household, brothers and sisters of the whole or of the half-blood, and children, including adopted children. In deciding whether Shemaiah Frierson had reasonable cause to believe and an honest belief that the defendant will cause serious physical harm to her or a member of her immediate family, you must put yourself in the position of the alleged victim with her characteristics, her knowledge or lack of knowledge, and under the circumstances and conditions that surrounded her at the time. You must consider the conduct of the defendant and decide whether her acts and words cause the alleged victim to reasonably and honestly believe that the defendant will cause serious physical harm to Shemaiah Frierson or a member of her immediate family. The state must prove that the defendant recklessly made the statement to or engaged in the conduct affecting the alleged victim with an understanding of the threatening nature of the statement or conduct. A person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk if the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person acts reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. If you find the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all the offenses charged. It is alleged that the alleged offenses took place on August 11, 2024. It is not necessary that the state prove that an offense was committed on the exact day as charged in the indictment. It is sufficient to prove that the offense took place on a date reasonably near the date claimed. You will have in the jury room the following verdict forms. Each states, "We, the jury, being duly impaneled and sworn, find the defendant," and then there is a blank. You will fill in either guilty or not guilty according to your findings. There is a place for 12 signatures. Your verdict must be unanimous, and all of you must sign the verdict form in ink on the line next to your juror numbers. Counsel will now present their closing arguments. Remember, the closing arguments are designed to assist you. They are not evidence. The state of Ohio will go first, followed by the defense. The state of Ohio will have one last opportunity to address you since they have the burden of proof. Ms. Cutts?
Thank you, Your Honor. Bigger, stronger, and angry. Holding her niece down by her throat, punching her, and threatening to kill her with her gun in her hand. That's what happened on Sunday, August 11th of 2024. Shemaya Frierson was living with her grandmother and her young daughter Bria in apartment 618 in the Pine Ridge Apartments on Parr Lane in Willoughby Hills, Lake County, Ohio. She had been living with her grandmother for a period of time. Grandmother had one room, Shemaya and her daughter had another bedroom. In April of 2024, Benita Fryer and her daughter Dayani move in. They move into the apartment in the living room. Benita Fryer is Shemaya's aunt. Shemaya's father is brother to Benita. They are a blood relationship. They'd been living together for multiple months when Shemaya's grandmother, who was Benita's mother, had a stroke on Saturday, August 10th of 2024. Since Shemaya's grandmother was out when this happened, besides obviously visiting her in the hospital, they also needed to get her car back from the parking lot that it had been left in when she needed medical assistance. So Benita drove Shemaya to that vehicle. So Shemaya had the key fob. She takes her daughter, she takes a car seat out, puts a car seat in that car, and drives the vehicle back. That's on Saturday, August 10th. So Shemaya has the key fob. The family is visiting grandmother on Saturday. They go back on Sunday. Shemaya is driving her grandmother's car to the hospital. So in the evening of August 11th, 2024, Shemaya and her daughter, Bria, as well as the defendant, Benita Fryer, and her daughter, Dayani, go to the hospital to visit grandmother. They're visiting with her. She is indicating that she has something, a key that has to go to work. She needs somebody to do that. That key is in grandma's car. So after they're getting ready to leave, Shemaya takes her daughter, as well as Dayani, Benita's daughter, defendant's daughter, and drives them home. So the three of them go home together. They get home first. Shemaya grabs the work key, brings it upstairs, puts it on the table, so that whoever's gonna take it has access to it. It's in the apartment. Shemaya goes into her bedroom, her daughter's with her, Dayani stays in the living room area. In the home, as you see, in State's Exhibit 2A, is the apartment door. When you walk into 2B, that's walking into the apartment where you can see the living room area. If you go further into the apartment, when you walk in the door, if you take a right, you go to the kitchen, where you can see the table in the State's Exhibit 2C. If you, from the doorway, take a left, you walk towards the bedrooms as shown in 2D. And as you can see in 2D, and quite frankly 2C, where the door comes in, there's a narrow hallway and then a couch into the living room. So Shemaya goes down after dropping the key off in 2C at the kitchen table. She then walks to her room, down hallway 2D into her bedroom, State's Exhibit 2E. She has a bed situation where it appears to be a couch like a day bed, and underneath is a bed that slides in and out. It rolls back and forth. So she is in her room with her daughter. It's when she hears Benita come home. Defendant comes home, slams the door, she can hear her voice. The living room and Shemaya's bedroom share a wall. Easy to hear between the two. So she hears that her aunt has come home, slam the doors, talking. She can hear her saying loudly with her daughter in the room where the key is. She's asking for her grandmother's key. It's one related to work, one that was in the car. It's now on the table. It's around 9 o'clock now. As Benita is asking over and over for the key, demanding the key, wants information, her daughter doesn't answer her. So she yells to Shemaya in her room about the key. Shemaya yells back, it's on the kitchen table. And Shemaya comes out of her room, walks down that hallway. Benita is in the living room. She walks towards the kitchen, lets her know the key's on the table. So obviously, Benita's already worked up. She's already angry for whatever reason, wants that key. Once she knows where that key is, her focus changes to the key fob, the key for her mother's car, for Shemaya's grandmother's car. Now she begins demanding that. Shemaya does not give her the car key. She told you part of it. She's being very disrespectful. Also, her daughter's car seat is in that car. She doesn't want not to have her car seat, then she can't transport her daughter. It's also nighttime. They're all inside. It's after 9 p.m. So she doesn't give her the key. There is yelling, swearing, name calling. Benita's calling her dumb and little girl and stupid. And at some point, Shemaya calls her a bitch. Shemaya leaves this situation. It's verbal. She walks away. Nothing good is coming. She goes into her bedroom, but Benita follows her into her bedroom, not Benita's. Follows Shemaya into her bedroom and continues to make comments, make statements, and Shemaya's like, no, I mean, be respectful, things of that nature. And she slams her door. So at that point, they're separated by a door. Shemaya's in her room. Benita goes back to the living room. As Benita says herself, everything calms down. At that moment, there's no more yelling or swearing. The verbal has stopped. A little bit later, she's in her room, her door's closed. Shemaya opens her door, but she stays in her room. So she stays in her room. She is, as she explained, the bottom bed is only out enough so she can sit on it and lean her back against the rest of the bed. So it's out partially, but it is on rollers, so it does move. So after she opens up her door and is sitting there, watching TV, seeing the screen in the evening hours, defendant comes right back in. Benita comes back in, she's starting again, yelling, swearing. Shemaya doesn't want her in her room, she's just come back into her room, there's no reason for it. And she comes at Shemaya and takes her hand on Shemaya's throat. Shemaya's still sitting on that bed and forces her down, basically onto the bed, which slides, and she goes in between the beds. So she's on her back with Benita on top of her. As she described to you, Benita has one knee kind of in the right groin area and one knee on her inner left thigh. She's on top of her, digging her knees in, their hand around her throat, hitting her, punching her with her other hand. As Shemaya is struggling, she's moving her arms, trying to find out, gripping, grabbing, anything to try and get her off. Easily able to scratch her as she's trying to do this. She even mentioned that she had put her hand under the bed. Her left arm was under the bed based on the positioning, see if she could find anything to try and get Benita off of her. Benita again, bigger, stronger, angry. As Benita told you, she at that point weighed about 240 pounds. As Shemaya indicated, she was about 120, 125. So clearly had more strength and more weight to hold her down. She's holding her down by her throat, squeezing. Shemaya's having trouble breathing. She's struggling, but she can't seem to get anywhere. She can't get up, she can't. Now she doesn't lose consciousness, but she is worried if she won't stop, what's going to happen. Will she lose consciousness? Will she pass out? Anybody who has had their throat pushed on in the front, grabbed, squeezed, it's a very sensitive area. It doesn't take long for somebody to be in trouble with their ability to breathe and to pass out or to lose consciousness. Thankfully, she did not, but the risk was there, and she was scared. This goes on, Shemaya feels, for a very long time. She just can't get up. But then the defendant, Benita, sees the key, gets up, takes the key, leaves Shemaya's room and also the apartment. You can hear the door close, she leaves. So Shemaya is stunned, still having trouble breathing. She had more trouble breathing when the hand was around her throat, but still trouble breathing, catching her breath, trying to make heads or tail of just what happened. As she said, anxiety, things of that nature. She was in panic mode. She didn't know what to do. She presumes the defendant's going down to grab the car seat and then come back up. So she thinks she's coming back. She's concerned. She doesn't know what's going to happen. So just thinking of protecting herself and even her daughter, in her room she sees part of her child's trampoline, a leg of that. So she takes that pole and puts it on the couch. So you can see in State's Exhibit 2B, the couch is not far from the front door. So she puts the pole on the couch, and she tells you she's kind of pacing, like what's gonna happen, trying to still process, figure out what just happened with her aunt. What is going on? All of this. So she doesn't stand there with the pole, but she's waiting and has that option in case she feels she's needed. Because she was just slammed down to the ground by her throat, hit, she's hurting, she's upset, she's scared. She's a 21-year-old girl with her almost 40-year-old aunt, just been aggressive with her, hurting her, pulling her down, holding her down. And again, Benita's bigger, stronger, and angry. So at this point, Shemaya hears Benita come back up. She can hear her in the hallway. She can hear what sounds like the car seat drop, what she's expecting her to bring back. And she realizes she doesn't want her to come in the apartment. So she wants to keep her out. However, Benita, again, bigger, stronger, angry. She's able to push open the door. As they're struggling with the door, Benita is bringing her arm around the door to grab at Shemaya. And as this is happening and she's getting in the door, Shemaya is able to lean back, grab the pole. She's going to defend herself as Benita comes in, or is coming into the apartment. However, again, Benita is bigger, stronger. She goes to use the pole, but she doesn't have any ability to do it. Benita grabs it, pulls, yanks her hard enough that she comes out of the apartment and entry and goes into the hallway. And then Benita's able to get control of that pole and it goes to the ground. It's not being able to be used at that point in any way. At that point, Shemaya sees Benita put her hand in her purse and she pulls out, first what she sees is a purple object, but it's a gun. She knows she has a gun. She's waving it back and forth, purple holster, saying, I'm gonna shoot you, waving it back and forth. Shemaya is shocked by a gun. She doesn't know she has a gun. She has this item, scary, so she slams the door, gets in, slams the door. She can hear through the door, her aunt is still yelling at her, calling her different things, calling her crash out. And she realizes her daughter is in the hallway. When this was all happening, Dayani, as well as Benita, as well as Bria and Shemaya were in the hallway. So when Shemaya slams the door, she has to reopen it so she can get her daughter. So she grabs her daughter, takes her on her left hip, tells her I'm calling 911, makes the phone call, has the phone up against her right ear. Benita comes in, and as she has her back to Benita, she has gone left from the doorway and is in that hallway, still near the couch, but she's facing away. Benita grabs her by her bun, starts hitting her. So much that the phone is hitting against her face, her right ear and her cheek. She's on the phone call with 911, and you can hear on that what is happening. And it's, so on the 911 call, initially,
Understood. The location of your emergency. Hello?
Somebody just came in here and attacked me while my daughter was in the room.
Okay.
In my face.
What address?
What
address? What apartment number? What apartment number? Okay. Do you need an ambulance? Okay. Do you need an ambulance?
No, ma'am. I mean, I don't know. No, ma'am. I mean, I don't know. Like.
so you'll be able to listen to State's Exhibit 1 as much as thoroughly as you deem necessary. But you will hear on there that somebody just came in here and attacked me. She identifies her as Benita Fryer. You can hear at one point where there's actually the interaction going on where Benita is hitting her. You can hear she's screaming. You hear all that. Shemaya goes through the basics of what has happened. She's asking for help. She's not asking for an ambulance at that point. She indicates she hasn't even checked out herself. She's very upset that the gun was waved in front of her daughter. She's very upset that her daughter was in her hands when she was being attacked the second time. And while this is going on, the defendant leaves the apartment. She knows Shemaya is on the phone with 911. She leaves the apartment to go put her gun back in her car. State's Exhibit 4 is the firearm, as well as you can look at the actual firearm in State's Exhibit 6. And it shows the purple holster that Shemaya had indicated. She saw the purple come out, saw that she had a gun, and was waving her at her and threatening to kill her. So the police come. Defendant is coming from the parking area, coming from her vehicle where she was just able to put the gun back in her car. And she admits there was a verbal and physical altercation with the niece she lives with. She lets them know that lives in 618, apartment 618, with her mother, her daughter, her niece Shemaya, and her niece's daughter. Got in the argument over the use of her mother's car, and there was swearing. She admits Shemaya slammed the bedroom door in her face and called her a bitch. She says every situation was diffusing. They're in different rooms. She says, so everything was cool. But then the defendant, Benita Fryer, goes back to Shemaya's room after everything is fine and starts arguing with Shemaya again. She admits to taking Shemaya to the ground and holding her to the ground. You know she was holding her on the ground by her throat as Shemaya struggled against her. Defendant admits she's much bigger, stronger, has more weight on her to use that force against Shemaya, who is small. She even admits saying, "Little girl, stop, because I will fuck you up. Just stop." Benita then leaves the apartment and goes down and gets the car seat. Again, perfect time to get her gun. In the bedroom, there's no gun, there's none of that. The bedroom is the hands on the throat, holding her down, striking her until she gets the key and leaves and runs out. She leaves the apartment, goes and gets her gun. She returns to the apartment, and she also says Shemaya has a pole. But the defendant grabs the pole, gets control of it. Defendant admits saying, "I will shoot you." She claims her gun's in the car, but she has just been down to the cars and was able to get her gun. And from the information you heard from the testimony, Dayani had also given information to the police that was consistent with the gun being present at the apartment and not in the car. Police locate the gun, and it is in the purple holster. You'll be able to listen to that in Exhibit 5, the statements that were made by Benita Fryer. So the gun in the purple holster is located. Initially, Shemaya declines medical when she's first on 911 and when Patrolman Jones comes and speaks to her in her room. Some time is going on as the investigation is going on. Patrolman Jones leaves the apartment, comes back, and goes into the kitchen with Shemaya, where there's better light, so that they can talk, get paperwork done. At that point, Shemaya is clearing her throat a lot. She's clearly not feeling well of the neck. She has visible injuries on her. But because her throat continues to hurt and feels tight, she's indicating she's still having trouble breathing, that her throat is feeling swollen, it's hard to swallow, all related to the squeezing of her throat, cutting off her breathing abilities when she was being held down. So at that point, paramedics do come for Shemaya to check her out. She's more comfortable with them coming to the house. She doesn't want to leave. At that point, her daughter and Dayani are both still there. So Shemaya was able to explain to you different injuries that she had. So in State's Exhibit 3A, she talked about, so evidence of her tears lower on to the right of what would be her chin, but looking at the picture, the left to her lips. Sure, a little bit above that is a cut that she has on the right side of her cheek, close to the cheekbone. There's raised redness and what it could be called, was called lacerations or abrasions. And then inside her right ear, you can also see where there's blood from cuts in there. When you look at her throat, you can see a marking in basically the middle of the throat area. She indicated in State's Exhibit 3C that you can see more of the blood in the ear as well as the marks on her cheek, which are consistent with the phone being struck into you see it in the printed out version, it's clear, but above the red mark, the red covering in some clothing, there is a mark, abrasion, that was from having Benita's knee in her right kind of hip groin area. And then 3G and 3I show kind of the beginning progression of the injury, the bruising, the black and blue on the inside of her left thigh, which is again from Benita's other knee coming down, one up in the pelvic area, one on the thigh. She was watching it as it progressed because it was becoming painful, and in 3I, she was concerned when she felt she saw a vein in the middle of the way the injury was going. So she took that picture about August 19th, about 8 days afterwards, and that's when she went to the emergency room because she was concerned about it. It was hurting, she was still having pain. She went to the doctor about that. They gave her some prescriptions. They gave her a wrap to put around her leg so that she could hopefully heal and get some relief from that. But I would ask, as well as you'll be able to look at the pictures, sometimes the pictures when you hold them in your hands are a little more able to see some of the injuries that when they're put up on the board can lose a little bit. So State's Exhibits 3A through 3I will show you those injuries. So you've been told what the charges are. I'll go over them with you. So count 1, strangulation. On or about August 11th, 2024, Lake County, State of Ohio, Benita C. Fryer created substantial risk of serious physical harm to Shemaya Frierson by means of strangulation or suffocation. So this is what we're talking about in the bedroom when she slams her down by her throat. Her hand around her throat. At one point, she indicated she had 2 hands around her throat just before she got up, creating a substantial risk of serious physical harm. So as we mentioned before, the throat can be a very sensitive area. Anybody who touches it, pushes on it, can feel that. So the more pressure and the longer you leave pressure on somebody's throat when they're having an inability to breathe does create a substantial risk of loss of consciousness, which would be a serious physical harm. Substantial risk is a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. So there is a risk of physical harm just by the mere use of pressure on the throat, a sensitive area that could lead to loss of consciousness, passing out. And serious physical harm has multiple definitions. The judge read all of them to you. Some of the ones that would be more related to this aspect is any physical harm that carries a substantial risk of death. If you stop breathing for a period of time, not especially long period of time, there is a risk of death, as well as any physical harm that involves some temporary substantial incapacity. So if you lose consciousness, you have substantial incapacity. Thankfully, it's temporary as opposed to death, which would be permanent, but loss of consciousness does fall under serious physical harm. Strangulation or suffocation means any act that impedes the normal breathing or circulation of the blood by applying pressure to the throat or neck or by covering the nose or mouth. We are not talking about covering the nose or mouth, but we're talking about an act that impedes normal breathing. We had multiple times when Shemaya indicated that when she was being held down, she was having trouble breathing. Even when that stopped, because it doesn't instantly change, when she had her hand off of her throat, she was still having some trouble breathing. The officer could hear her clearing her throat. She indicated that to the paramedic that came as well. So clearly her breathing, her normal breathing was impeded by the acts of her aunt, Benita Fryer. Count 2 is also strangulation, but there is a difference. So you will look at them separately when you determine. On or about, again, August 11, 2024, in Lake County, State of Ohio, Benita C. Fryer caused or created serious physical harm. We're talking about physical harm. So either causing it or creating a substantial risk of it. So we went over substantial risk, a strong possibility that a certain result may occur. But the difference with physical harm versus serious physical harm is physical harm is any injury, illness, or other physiological impairment regardless of its gravity or duration. So that means a cut, a bruise, even if somebody just feels hurt and no marks, or a red mark, all of those would fall under physical harm. So you definitely have this here. You have the swelling, you have the discoloration, you have the mark on the neck from the finger going in. All of those would go towards the physical harm. So it wasn't just a substantial risk in this incident, she actually caused it. Even if there weren't injuries there, there's still a substantial risk of physical harm when you put your hands on somebody the way that Benita Fryer, the defendant, did on her niece, Shemaya Frierson. And again, strangulation, suffocation, we're talking about the act of impeding the normal breathing by applying pressure to the throat or neck. Same aspect of that. So when we're talking about a family or household member, it's a person related by consanguinity or affinity to the defendant and who's residing or has resided with the defendant. Nobody's arguing that they were living together. They've been there since April of 2024 through this August 11th of 2024, living together. Shemaya had been there first, but when Benita moved in, she was living there. And they have a blood relationship, the aunt to niece, with Benita being the sister of Shemaya's father. So we have a blood relationship there. So they are family or household members. Counts 3 and 4. They deal with two different aspects of what happened, but they have the same information. So on or about August 11, 2024, Lake County, Ohio, Benita C. Fryer knowingly caused or attempted to cause physical harm to Shemaya Frierson, a family or household member. So domestic violence obviously is based on a relationship as well as cause or attempt to cause physical harm. In this case, you have what happened in the bedroom, and then there was a break in time. What happened in the living room when Benita came back would be the separate, that's the difference between the two domestic violence. The locations, they were not a continuing course, there was a break in time. So physical harm, again, same thing. Cuts, bruises, injuries. You know there's the cut over her left eye. You know that there's the cut below her nose but above her lips. The marks on the side of her face and in her ear. All of those would go to the domestic violence from the two different locations where she was either causing or attempting to cause. So we know injury was caused, but also there was the attempt within it. Family or household member, same aspect. They live together, they have a blood relationship. And then we have the aggravated menacing. So on or about August 11, 2024, Lake County, State of Ohio, Benita C. Fryer knowingly caused Shemaya Frierson to believe that the defendant would cause serious physical harm to her or a member of her immediate family. So this is when she pulls out the gun, waves the gun at her, and tells her she's going to kill her. Shemaya sees the gun. She is scared. The gun is capable of causing death. And she has every reason to believe that the carelessness with which she was moving the gun around, knowing that a gun is capable of death, rises to the level or causes her to believe that she would cause serious physical harm. And her daughter is there as well. As she says on the 911 call, states Exhibit 1, as well as she said here, her daughter was in that hallway. So she's waving that gun. If that gun was fired, could definitely cause serious physical harm, and that was her fear and her belief. So this serious physical harm, the definitions are still the same, but you're dealing with physical harm that carries a substantial risk of death. If she were to have fired the gun, that could be a permanent incapacity, or again, a temporary substantial incapacity. It could cause permanent disfigurement or temporary serious disfigurement. And even if a gun firing didn't kill, it could cause acute pain. So all of these are possibilities. So it just has to be that Shemaya Frierson believed the defendant would cause serious physical harm, that Benita's actions caused her to fear that for herself or for her daughter, her immediate family. So immediate family includes a person's children. So Bria is her daughter, as she indicated. State asked you to review all of the exhibits. Review in your mind all the testimony, go over all of it. Once you have reviewed everything, considered everything, state asked you to hold the defendant responsible and accountable for her actions and find her guilty of both counts of strangulation. One for creating a substantial risk of serious physical harm, that being loss of consciousness or even the possibility of death, as well as the second count for causing physical harm or creating a substantial risk of physical harm. We know we had the physical harm with the swelling and discoloration and the marks, and there was potential for worse. And both counts of domestic violence, in the bedroom, hitting her, causing or attempting to cause, as well as in the living room, again, pulling her by the hair, hitting her, having her phone smack into her face and her ear. Both of those were an attempt to cause physical harm, and then there was physical harm. And the aggravated menacing for pulling out the gun and telling her, I will shoot you. Would ask you to consider everything and then find the defendant responsible and accountable for her actions and find her guilty. Thank you.
Thank you, Mr. Nicholson.
Thank you, Your Honor. Well, ladies and gentlemen, we are finally at the end. And we are at closing arguments. And first off, I want to thank each and every one of you for sitting on this jury, for giving your time and giving your attention to this case. I didn't see anybody fall asleep. So again, I appreciate you doing your service. Now, I told you before this case started that at the end of hearing all the evidence, and if you consider all the testimony and the truthfulness and the untruthfulness of the testimony, that you would have more questions than answers. So we're going to talk about some of those questions. Question number one. Why did Shemaya lie about her relationship with her aunt? She referred to her as this lady. This lady just came in and attacked me. She made it sound like that this person was a stranger, some intruder, some random person that just ran up in the house and started attacking her. That was untruthful and that was fraudulent. And we'll get to why. Now, when it's convenient to her, she'll refer to her as auntie. And you heard on cross-examination. See, it wasn't until Miss Jackson asked her questions to where she started getting into the relationship and the extent of the relationship with her auntie Benita. She told you, well, through her testimony, it was learned that she came from Georgia, didn't have any money. Who helped her come from Georgia? Auntie. Who assisted her financially in coming from Georgia? Auntie. Not this lady, Auntie Benita. Who gave her a job? This woman was homeless, no job. Who gave her a job? Auntie Benita. In fact, you heard on her testimony when Ms. Jackson was asking her questions on cross-examination, she talked about how she even went to her house and did Auntie Benita's hair. But she's just this lady. She wants y'all to believe that she's some random lady and some stranger and some intruder. She don't want you to know the real story, that this woman loved and still loves Shemaya. She don't want you to think that. Why did she leave that out? Why didn't she tell police that? I don't have the answer to that question. She downplayed her relationship. She came to this court and she was fraudulent. She was fraudulent at best.
Objection.
She wasn't honest. Overruled. She downplayed her relationship. Now, my next question. Why such an incomplete investigation? This investigation was incomplete at best. It wasn't thorough. Why? And I'm asking why because got at least four officers on the scene, including a sergeant who graduated at the top of his class. You heard him say that. He's a sergeant. He corrected me on the record when I said officer. I'm a sergeant. Okay? Know what that sounds like to me? That's a higher level than an officer. Promotion. You had a supervisor on scene. You had a supervisor on scene. You had a lead officer on the scene. And you had Officer Warren. Now I couldn't count, wasn't able to count all the years of experience. I heard 7 here, 10 here, all this training and everything. I would say there was at least 10 to 15 years of law enforcement experience in that house that day. They talked about, every officer that testified talked about all the training that he had. Went to the academy, did in the field training, did all that. But an incomplete investigation. Now let's get into details of that. We'll start with Officer Mir, the lead officer on this case. You're the lead officer at the scene. Speak to one person. One. It's Willoughby Hill's finest. That's what we got that day. One person and you are the lead officer on the scene, and you talk to one person. Auntie Benita. Saw the video, and you'll be able to see it, his interaction with Auntie Benita. You'll be able to see his interaction with her. I want you to pay close attention to that, and I'm going to get to why. But when you get that, and I hope you took notes on it, but if you need to be refreshed with it, just look at it. You'll have that video. A lot of details in that video. But remember when we talked about instant replay on their voir dire and jury selection? Now you have the chance to use instant replay. And I want you to utilize that seriously when coming to a conclusion as to whether my client is innocent or guilty. Officer Mir testified that he had all this training. That he was trained to gather facts, to gather evidence, to interview witnesses, to do all this stuff, and then he's trained to make a determination as to who to charge. But ask yourself this question, ladies and gentlemen. Did he really look at all the facts? Did consideration. Statements from everybody. Did he? No, he didn't. But his training says that he needs to take all the facts, interview the witnesses, and then make a determination. But he didn't do that, did he? No, he didn't. And he told you he didn't do that. Let's talk about what else lead officer Meir did, the lead officer on the scene. Let's talk about who he did interview. He interviewed my client, Ms. Fryer. At least he did that. But he left a lot of stuff out. For instance, you saw it was about a 30-minute conversation, interview, whatever you want to call it, with Ms. Fryer. Gathered all that information, took photos. And remember when all those officers were on the stand? Remember when they said that, when it's multiple officers on the scene and multiple witnesses? Remember when they said that? And each one interviews a witness, and they come all together at the end and talk about what they found out. Well, it's quite concerning, and it's interesting. Maybe it's a coincidence that Officer Meir didn't tell any of his colleagues anything that he learned from what Ms. Fryer told him. He didn't think it was important. I mean, that's the only conclusion I can come to. Why didn't he think it was important? Why didn't he tell any of his colleagues, any of the other officers at the scene, at what he had just found out, at what he had just investigated? He didn't even tell them why he took photos. Didn't tell him anything. I'm not in his head. I don't have an answer for that. I don't know. Now, he took pictures. Your Honor, do you have those exhibits up there?
I don't have the exhibits are all down here.
Pictures of. He took pictures. You'll get those pictures. You get those pictures. You get those pictures. If you remember on the screen, when he saw that laceration on that leg, even he was surprised. You heard his reaction. Whoa! Took a picture of it. Now, we know that's a laceration and not a scratch, right? Because EMT worker, Dobsha, he gave us a lesson on what a scratch was as opposed to a laceration. You heard him. You heard him. And what did he say? He said lacerations are caused by sharp objects. Well, we know Ms. Fryer didn't cut herself. We know that it couldn't have been when she allegedly was sitting on top of her that she received that laceration on her leg. Because what? Lacerations are caused by sharp objects. Remember she said she was on the floor and she was trying to grab something? We heard no testimony of a sharp object at that point. And he took pictures. Officer Mir took pictures. Now let's talk more about the interview. Now look. Benita Fryer is just this violent person. You heard Shamaya testify. She's just violent. She was violent. Violent this, violent that. But you saw the interview. Did that look like somebody that was violent? No. Didn't. Did that look like someone who was irate? No. What did it look like? Did it even look like she was in a fight? No. Her demeanor was calm. She was cooperative. She wasn't screaming. She had no reason for the police officer or for Officer Mir to believe she was lying. She told you everything. She was forthright. You'll see that interview. Focus on it. She was calm. She was collected. And what did she say? What did she tell Officer Mir? She was attacked. Now, you heard at least 2 people testify that both of them called 911 around the same time. Okay? So, my mind, if somebody's calling 911, they're a victim. They're in distress. They are in need of immediate help. Call 911. The problem is, I guess we can assume we take some people's 911 calls seriously and not others. And that's the only conclusion I can come to. Because let's just be real. The system failed this woman that night. They failed her. She was clear, she was calm, she was honest. She was a victim. And she explained it. And her testimony is truthful, or not testimony, but her words were truthful. This was a biased investigation. Very biased. And why do I say biased? At least 3 times, and you'll see it in the interview, at least 3 times, when Ms. Fryer was trying to explain what happened, he interrupted her. Didn't let her get the words out. She was going one time, interrupted her. I believe she was trying to explain to him that the situation de-escalated at one point. You know what he did? Interrupted her. No, it escalated. That's bias. No one was able to do her justice. In fact, like I said, all the information that Officer Mir learned about the attack on my client, he didn't communicate it to his colleagues. He must have not thought it was important. I'd ask you to take a look at that. Didn't give it to his colleagues, but they work as a team. They work together. Share information with each other before they determine to make charges, to file charges. But see, now he wanted to try to say, well, we didn't know that she was going to get charged until she got to the station. No, they knew that she was going to be charged when they got there. When they heard that 911 call, they were biased, and they assumed that my client was the aggressor, even though both of them called 911. The lead officer really didn't even talk to Shamaya. The sergeant who graduated at the top of his class, who's a sergeant, didn't talk to Shamaya. Now they want to talk about daughter this, daughter that, my client's daughter she wasn't here. You didn't hear her story.
Objection.
Overruled.
But we did a thorough investigation. And one of the only other witnesses that were there, we didn't hear from. Now look, maybe she was talked to. I mean, but as incomplete as this investigation was, how can you believe that? We don't know. Now, even though that Officer Muir didn't tell anybody else about what happened, Officer Jones, Patrolman Jones, sorry if I messed it up, you saw through his testimony and you saw in that interview. Please look at the interview. Twice in court and on the day of the incident, he told the lead officer there's no swelling on her neck. No swelling. And did you hear him on his testimony? He forgot that he said that. So we had to refresh his recollection. And after his recollection was refreshed, he remembered, yeah, I said that. I didn't see any swelling on her neck, just scratches. The only person that can even remotely say anything with regards to any medical advice was EMT worker Dobson. Okay? But he couldn't even really say if there was any swelling on her neck. I mean, he did an exam, but let's talk about what he did say. When he walked in the house, when he walked in the apartment, she was calm. She wasn't holding her neck. I don't believe she ever told him she couldn't breathe. And what did he say? I asked him, you heard me. Did you assess her for a concussion? You're an EMT worker. He said, I can't diagnose with a concussion. Did you assess for one? He didn't say he did, so let's assume he didn't. And we'll get back to that. So you didn't really hear any medical doctors testify or diagnose Shamaya with any swelling in her neck or being strangled. Would have been nice if we had that, but we didn't. So we can't really make an opinion as to what happened medically.
Objection.
Overruled.
Sergeant Kokenauer, okay? I mean, who did he talk to? He's a sergeant. Who did he talk to? And he said, and remember, he said, based on the totality of circumstances, we determined that Benita Fryer should be arrested. He said that in so many words. Didn't say that verbatim, but you heard him say what he said. What investigation? What totality of circumstances? How do you make a determination to arrest my client when you don't even know she was attacked? When you don't even acknowledge the fact that she called 911? When you don't even take her story into consideration? How is that a totality of the circumstances? Incomplete investigation. Now, when I talked to you at opening, I asked you, please do not check your common sense at this door of the courthouse. You're allowed to bring your common sense in here. So let's talk about common sense. common sense. Coming in a room, choke slam, by the way. Y'all heard that? Boom! Choke slammed her. Squeezing her. You heard State of Ohio on the closing said she squeezed her. Squeezing, squeezing, squeezing. And you heard Shemaya say the whole time. She was squeezed the whole time. Squeezing. Punching. 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 Squeezing. Choking. Suffocating. Can't breathe. If you want to believe that. But let's talk common sense. Now, y'all saw the pictures. Y'all saw the injuries. Alleged injuries. Now, when you use your common sense, ladies and gentlemen, I know, you're going to see these pictures in the back. You tell me, please make a determination if these injuries are consistent with somebody being choke slammed, number one, choke slammed, on the floor, by the way. On the floor, by the way. On the floor. The hard floor. We didn't see any back injuries on Shemaya. See any bruises on her back. I'm going to go as far as saying bruising on her neck. You be the determination. You be the determiner of the fact of that. No bruising, no swelling on her neck. They want to say something like this. That's the thumb. That's the thumb part. That's from her thumbnail. That proves strangulation, that she choked her. Come on. This? Because that's how big it is. Just look at the picture. Common sense, ladies and gentlemen. Don't fall for that. Don't fall for the head fake. Use your common sense. And you determine whether this is consistent with being choke slammed and punched in the face. Oh, we're going to get to the punching in the face. You remember when Officer Mir took the photos? Took the photos of her hands? Y'all remember that? You remember that? Saw two clear pictures of the hands. And you remember when Miss Jackson asked Officer Mir, do those hands look like somebody's been punched somebody multiple times? What was his answer? No. No, he said that. You saw her hands. Now look. Choke slam. Okay, then I guess you would have to, because my client's right-handed, I guess you would have to choke slam her, take the hand off, choke her with the other hand, punch, 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 punch. Those pictures, those injuries are not consistent with what Shemaya got on this stand and told. You saw my client's hands. Nothing indicative of her punching anybody. Nothing. Look at those hands. You'll get the pictures, you'll get the exhibits. Pay attention to those. Because we heard a lot about punching. Punching at the door, punching in the room, all this stuff about punching. But my client's hands are not consistent with hands that have punched somebody several times. And she made it sound like she got punched a lot of times. Common sense. Let's go further with our common sense. We had the 911 call. Never said she was choked in a 911 call. Said she was punched. But we know that's not true. Injuries ain't consistent with being punched. Several times. Listen to that 911 call. If you were strangled, suffocated, all that, that's the first thing you said. She didn't say it on a 911 call. And all this, trouble breathing, hard to swallow, and all that, well, go to the hospital. Go to the hospital. You got trouble breathing, you can't breathe, you can't swallow, go to the hospital. She was asked multiple times whether she wanted to go to the hospital. She said no. And we can go for the head fake. Oh, I didn't want to leave my daughter. I didn't want to leave my daughter. I'm in so much pain. My life was just almost taken from me. But I'm not going to go to the hospital. After Dabcha, he told you. Dabcha testified. You saw it. Him and at least 3 other people told her to go to the hospital, recommended her to go to the hospital for precautionary purposes. She said no. Now, like I said, don't go for the head fake. Oh, I want to leave my daughter. I want to leave my daughter. No. EMT worker Dabcha said, oh, we can accommodate. Bring your daughter with you. Why do you go to the hospital? Because it wasn't convenient for her to go to the hospital. Because she didn't have to go to the hospital. Because she didn't suffer physical harm or serious physical harm. She didn't think she was going to die. She didn't think she was going to pass out. She didn't think she was going to be unconscious. If you do all that, you go to the hospital. She didn't go to the hospital. Oh, sorry. 8 days later. 8 days later, because of a phantom bruise that just appear in your leg. None of the officers took a picture of that bruise. She took those pictures. And you know what else she said? Did you see that little red thing on there? She said it was an emoji. And does anyone, well, I don't know if everybody knows what an emoji is. She said it was an emoji. She put that on there. She altered that picture. Could be possible she did something to the other picture she took. I don't know. It'll be for, ladies and gentlemen, for you to determine. Now, let's talk about, we're still in common sense. But let's talk about Shamaya and her actions, okay? Particularly how she sat here and she tried to say that she was afraid for her life. I felt like I was gonna pass out. She said it here. All this stuff, okay? Now, Miss Fryer, bigger, stronger, angry. Remember those words. Miss Fryer just chokeslammed her right on the floor, choked her for several minutes. I'm gonna lose my life, all this. And then all of a sudden, she gets up, looks away, goes downstairs. Why did she go downstairs? To get a car seat. Now they want to try to make you believe that she went down there to get a gun. Does that make sense? Does it really make sense that she went down there to go get her gun? Now State of Ohio put all this stuff on the PowerPoint and on the screen, talking about she had an opportunity to go get a gun. Does it make sense though? Allegedly, I just chokeslammed you. She was just chokeslammed. She was just punched and all that. And you heard Shamaya say, "Oh, I just felt defeated. I felt defeated." So why is Benita going to go to her car after she allegedly just almost killed this woman? Why is she going to go to her car and grab a gun? That doesn't make sense. And you heard testimony that she didn't even go to her car. She went to her mother's car. Why? Well, we know that she really did because she had the key fob. Shamaya told you, took the key fob. Went down to her mother's car to get the car seat. Nobody got a gun. Use your common sense. Again, it doesn't make sense. Why would she go get a gun? Now let's talk about Shamaya's actions. Now, you heard Benita's side of the story. You heard it. And I want you to really pay attention to that when you go back in that jury room, because her words were consistent with what happened. She didn't lie. Her allegations of injuries, her injuries were consistent with her allegations. She was calm, collected. So, Benita, after all this stuff she does, she goes downstairs. What does Shamaya do? She told you. Shamaya goes and gets a pole, a metal pole at that. You'll have a picture of that. I don't have it with me right now, but you're going to have a picture of that pole. You're going to have a picture of it. And what does she do? You heard Miss Jackson when she cross-examined her. Why don't you just go in your room and lock the door? Nah, she didn't want to do that. She wanted to get violent. She wanted to hit her with that pole. She had every intention of hitting her with that pole. You know why? Because she was mad that Benita took that key. This when Benita just attacked her and this and that. No, she was mad that Benita took that key. And my client didn't admit, she held her down. You know why? Because she was crashing out, acting crazy, out of control. You'll see that in the interview. Held her down like, not little girl, I'm gonna kill you. Like, little girl, chill. I'll F you up. Like, you need to calm down. This is crazy. Chill out. That's her auntie. She don't want to hurt her. Heck, she assisted her in getting down here. She got her a job. Allowed her in her home. Let her come. She tried to say that whenever she would go to her home, Shamaya, whenever she'd go to her home, she was never there. I don't believe that. But let's just assume that's the case. They have such a good relationship, or such a bad relationship. Bad relationship. Benita lets her go in her home and wash her clothes when she's not there. Benita allows her to be around her daughter while she's not there, but she's so crazy. She don't love her. She just wants to beat her up. No, absolutely not. No choking took place. No strangulation took place. My client told you what she did. The girl kicked her and she restrained her. That's it. She pulled her up, pulled her down, and restrained her. She didn't choke her. She didn't attempt to cause no harm. She wasn't intending to cause no harm. She was intending to hold her down so she would calm herself down. Like, chill. Because if you want to do this, we can do it. I'm sorry. Bigger, stronger, angry. She had her down like that, she could have caused way more damage. Way more damage. Bigger, stronger, angry. Remember, she was 240, and she said she was 110, 120. Way more damage. Bigger, stronger, angry. Common sense, ladies and gentlemen. This investigation was tainted by the 911 call. Now, let's go back to Shamaya's actions. After Benita holds her down, calms her down, like, look, chill out, no choking happened, none of that. And you know what? It's possible, all these scratches and stuff like this, all this, it's possible she causes herself acting out of control. That can happen. Okay, so Shamaya just got brutally attacked, okay? And Benita leaves, goes downstairs, get the car key, or excuse me, get the car seat. What does Shamaya do? Now tell me if this is a victim. What does Shamaya do? She knows that Benita left. She knows that when she comes in, she's gonna be vulnerable. And you know what she does? She get that pole. She gets that pole, and y'all, you get the pictures. You see how small that apartment is? I mean, here's the door, and there's something right here. What did she say she did? I got that pole. Because I didn't know what she was gonna do to me. I didn't know what she was gonna do, so instead of locking myself in my room, that has a lock on it, by the way, and you heard her testify to that, and you heard her testify when her room was locked, Benita didn't come in. So you just got you just almost lost your life. But you want more. You want more. You want to attack the client, your aunt. So what did she do? You remember she said, I put it in behind the couch. She didn't want Benita to see that pole. She wanted to catch her by surprise. Put it behind that couch. And what she say? Pace it. Waiting for Benita to come back. I'm pacing. She's getting ready to attack Benita. Pacing. That don't sound like somebody that's short of breath that can't breathe. Pacing. And what does she do? Benita come in that door. It's up in the air how the door opens. It's up in the air, but we do know. Once that door opened, wham, wham, you heard her. She said she hit her in the head. Shamaya told you she hit her. Shamaya told you she hit her with that pole. And what happened? Blocked it, grabbed it, threw it down. Now, bigger, stronger, angry. If she was intending on seriously injuring her, Shamaya, why didn't she just beat her with the pole? She just got hit with the pole herself. Why didn't she just beat her with the pole? Why? Oh, because she pulled a gun out. Oh, let's believe that. She pulled a gun out in a holster, by the way, and waved it around. In a holster. Now, if you want to believe that, but come on. Why go downstairs and get a gun? Now, Shamaya testified that she didn't know that she had a gun prior. Come on. You've been to somebody's house. You do their hair. You're around them all the time. You mean to tell me she didn't know that she had a pink case on her gun? And she didn't just think about that, oh, she had a pink gun, boom. Thing is, the gun never came out. Gun's black. Never came out. And waving it. Okay. State of Ohio told you this part right here is a very sensitive area. Very sensitive area. No marks. And they talked about the front. So focus on the front. No marks. This is a case where, quite frankly, a child or a young adult has no respect whatsoever for the aunt that got her down here, the aunt that assisted her financially, the aunt that assisted her financially and assisted her with her kid, the aunt that gave her a job, the aunt that she called if she wanted to take off, the aunt that she called if she had trouble getting to work, Basically, anything that she needed and she called her aunt, she did. But respect is earned, not given. Ain't that true? I didn't give her the key because she was talking to me some kind of way. Are you kidding me? Now we hear all this stuff with the phone hit the face and all that. She didn't testify to that. Testified she was punched in the face several times. Testified she was hit in the face with a phone. The phone made contact with her face. Testified she was punched in the face. Don't go for the head fake. Now, I don't know where this came from, but I've never heard Shamaya testify that my client ever said that she was going to kill her. Never heard her testify to that. I don't know where that came from. So, look, ladies and gentlemen, state has a burden. State has a burden, okay? And let's go through the elements. Strangulation, knowingly create a substantial risk of serious physical harm by means of strangulation or suffocation to a household or family member. Or, excuse me, I'm sorry. Knowingly create a substantial risk of serious physical harm by means of strangulation or suffocation. Okay? Now, you heard a lot about cause, the cause. So let's talk about cause, because you gotta have cause in order to satisfy all the elements. I don't believe they meet that burden, they satisfy that element. Because you have to prove, they have to prove that she knowingly caused, or attempted to cause. Well, let's talk about cause. She didn't choke her. So she didn't cause any type of harm by way of strangulation or suffocation. She never had her hands around her neck. You see her neck. She never had her hands around her neck. No cause. Domestic violence. Knowingly cause or attempt to cause physical harm. Nobody knowingly caused anything. Nobody attempted to cause any physical harm. You know what she did? She attempted to calm her down. It's my daughter, that's my niece. She attempted to hold her down so that she didn't have to do that. She didn't want to do that. Okay. Now, you got your jury instructions, okay? When you talk about strangulation, you talk about the element, you gotta knowingly, regardless of purpose, okay? To talk about knowingly, person acts knowingly when the person is aware that the person's conduct will probably cause a certain result. Well, she knowingly thought her conduct of holding her down was going to defuse the situation, which it did. It stopped. She got up, got the key, went downstairs. So they haven't satisfied that element, ladies and gentlemen, and please hold them to their burden of proof. Now think about this. Benita, I mean, the way that she describes what she allegedly did to her, you were seeing that Benita hated this woman. That's not the case. You heard Benita's interview. Benita explained everything. She corroborated Shamaya's statement that she hit her with a pole. She attacked Benita. You saw the injuries on Benita. But you know what? This woman didn't even want to press charges against her. It's a little neat.
Objection.
It's sustained.
Move to strike.
You know what? I'll withdraw that. Just watch the video. You'll see. You'll see. Just watch the video. And you'll see, when you hear from my client in that video, why she didn't write a statement and why she didn't want to press charges. You'll see that. Now, let's go back to the investigation. And I have to go back to this because I only get one chance. State of Ohio gets two, I only get one chance. So I gotta lay everything out. When Officer Neer was asked by Ms. Jackson, did you pull any camera footage or try to pull any camera footage? He didn't even answer the question. He said there's no footage. But what he didn't say was, well, we looked to see if there was footage, but we couldn't find any. He didn't even answer the question. Now, you heard Shamaya talk about how the walls are paper thin and all that. Y'all heard that. Walls are paper thin, you can hear it. But all those apartment dwellings, all those residences next to each other, you would think, serious case, investigation, you would think they would talk to at least somebody else that lived on that floor. I can't imagine that Miss Fryer and her family are the only ones that live on that floor. But they didn't. Paper thin walls too. Somebody could have heard something. Do you think that they even knocked on doors and asked? I mean, this was a loud altercation in a hallway that allegedly involved a child. Do you think they knocked on any doors and asked anybody if they heard anything? No. At least they didn't testify to that. Why not? I don't know. When Benita went in Shamaya's room to get those keys, she didn't have any intentions of attacking. Why? Why? It's very interesting that we're talking about how the grandmother had a stroke. We went to the hospital, we visited Saturday, so whatever. It's very interesting, but there's a lapse in time of an explanation as to why my client was mad. What happened? Out of nowhere, my client just gets angry, slams the door, and starts yelling. Nobody testified to anything that happened before then. Think about that. Why was she just... You heard that Shamaya drove her grandmother's car home. No argument about that. So what happened before? When did my client get mad? What happened to where my client got mad to all of a sudden come in the house and started acting angry. I missed that. I didn't see I didn't hear any testimony that explained that. She's attacked by Shemaya when she goes in the room to get the key. And when she's attacked by Shemaya, what does she do? She holds her down. Why? To calm her down. And you even heard Benita say when she let her up, when she got up, she punched her. So she was trying to prevent her from hitting her again. You'll hear that in the video. And she didn't want to press charges. So, look. Ladies and gentlemen, I ask you. Number one, I ask you again. I know I'm being repetitive. I ask you again. Consider the testimony. Consider the pictures. Consider the evidence. Consider everything. And please take your time and do it. There's a lot that was thrown at you. And you have a chance to do the instant replay. And I want you, again, I'm gonna leave you with this. I want you to really focus on those hands of my client. Focus on her hands. Remember? Focus on those hands. We've all hit something in our life before. We know what happens when our hands make contact with objects or people. Look at her hands and see if that actually happened. Just look at that. Now, when you take that with all the unanswered questions and the less than thorough and incomplete investigation, and when you consider all the evidence and everything, you will come to a conclusion. The state hasn't met their burden. There's a lot of reasonable doubt. A lot of reasonable doubt. Reasonable doubt as to whether there was even a gun that came in. You got to consider that. And when you consider everything, the truthfulness or the lack thereof, and the veracity and consistency of my client's interview and the alleged victim's testimony, please look at who is more consistent. Look at who is more calm. Look at who's more cooperative. And ladies and gentlemen, if you do that, if you hold them to their burden and you look at this thoroughly, we are confident that you can come to no other conclusion but an acquittal. Ladies and gentlemen in the jury, I was very long-winded, but I appreciate the service, and I appreciate you taking your time and sacrificing your time to sit and hear this case and consider everything. Thank you, ladies and gentlemen.
All right, ladies and gentlemen, I'll give you a short break. Remember, don't discuss the case at all, and don't think about what you're going to do until you get it.
All right, the jury.
Me too. Where are they?
Antonio, the last time I saw them is I think when you used them, they were like in the middle of the table, so maybe they just got scooped up with
Oh, my goodness.
I'm like, I know they're there.
I just took out. We just
Okay,
won't have to
yep.
go back, because these
Yep.
obviously are not related.
Yep. Thank you.
Yes.
How long? I think he said 10 minutes.
I think Bob's gonna find out, but. So.
Good Lord. All right, let me find these pictures though. No, these are some of them, but they're around. They're over here. Oh, here we go. You know what? I wanted to say, I've never had a trial with you, but very professional.
Thank you.
Very professional and thorough.
too.
Yeah, she was.
You don't just go like that. So can somebody give you shit?
I didn't punch a couple walls in my time. Do I know how to punch? No, I'm not a boxer. Hey, look. Hey, all these dudes talk about I got hands. I don't got hands.
Oh, I got no man.
Yeah, I don't got hands. I rap. Hey, y'all can throw the hands if y'all want. When we get that leg. Oh, yeah. Man, what, you think I want to mess this face up? I ain't fighting nobody. Shoot. Man, put up some hands, man. You can have it. Elements. You can have it. I'm not fighting. I'm hoping they want us here like in the morning, so I don't have to go to juvenile court. I do not want to go to juvenile court.
Heard a lot of things today. Please remember, it is your recollection of what is testified to that holds. Not what Mr. Nicholson says, quite frankly, not what I say. It's what you remember from the testimony that was said. So please, remember that, follow that, trust yourself. Also, follow the instructions that the judge gives you. There's some confusion as to which counts require cause and which ones create. You will have those wordings. Please follow the instructions given by the judge. There are various comments made about the investigation in this case. Please keep in mind, all of the witnesses were interviewed. The police came, they all interviewed, and the lead officer, the one who was making the decision at that time, had all of the information. He spoke with Patrolman Jones, who told about what Shemaiah had told her. He was also told what Sergeant Kokenauer got from Dayani, Benita's daughter. Also, back at the station, when Sergeant Kokenauer told him about his line of questioning regarding strangulation, Patrolman Muir had all of that. He's the one who needed to know all the bits and pieces so the determination could be made at that point. But now the determination is yours. You have now heard anything, have heard everything to make the determination following the elements and the information you received. This case isn't about whether the police did every little thing that it was possible. And what Patrolman Muir said was, there are no cameras. There was no camera footage to get. There are no cameras. So remember the testimony, reviewed that, but the investigation is over and it is now in your hands. You hear everything. The officers did get the information, they did the investigation, but this isn't about that. This is about the testimony you heard today. You got to hear from individuals who testified. There was also conversations about the relationship. So Shemaiah told you, and it becomes evident as you hear it, she was shocked by this happening. Her aunt became a stranger. So when she's getting attacked and she's on 911, somebody attacked me because she doesn't know who this person is anymore. That makes sense. She's in shock. She doesn't know what's going on. She's attacking me, somebody. But yes, did she tell the officers who this person was? Obviously. We all know who she was. It was just what was going on at that time. So yes, use your common sense. Absolutely. Listen to everything. Review everything. You will hear in State's Exhibit 5 when Benita is speaking. She keeps her gun in the car. She said there are signs that say no gun. She keeps her gun in the car. Excuse me. There's no reason Shemaiah would know she has a gun. Just because she's been at her house doesn't mean she shows her the gun. She told you she had never seen it before. She saw something purple. She saw the gun. She knew what it was. She talked about being in the military. She knew it was a gun in a purple holster. She's just shocked by the fact that it happened. And all the information that the police received from Dayani and from Shemaiah indicated that the gun was present. And then that gun in the purple holster was found in her car when she was coming from the parking lot. So it makes sense that she wouldn't know and why she needed to go down and get the gun to bring it up, because she was mad. She decided she didn't want Shemaiah driving her mother's car. She said it in State's Exhibit 5. So when she went down, it was her opportunity to get the gun. That's why when she came up, she told her, I will shoot you. And if you remember, Shemaiah walked away. When it was a verbal argument, Shemaiah walked away, went into her room, closed the door. It stopped. When she opened the door, she didn't come out. She stayed in her room. It's the defendant who came running into her room, getting into everything, slamming her down by her throat. So yes, Mr. Nicholson comes up here and acts out, but he didn't have Shemaiah acted out. It doesn't mean that she was switching hands and punching. She held her down. You can see from the pictures a thumb mark under her right ear, a cut that is consistent with her thumb going there, and having injuries in the front when you're pushing down. Usually when people get bruises or marks, it's because it's on a hard substance. So it's a harder area to bruise in general. But the swelling from the squeezing from the side that has injury on it, that is all consistent. And there are marks in the front of the neck that you will see pointed out in the pictures. And you'll also notice in State's Exhibit 5, when Benita is speaking, she doesn't say she got hit when she got up. If you listen closely, she got up knowing that at that point she wasn't going to get hit. Her plan was to hold her down until she submitted. And then she got up. There was no talk of being struck at that time. So you have a lot of information. You know what the elements are. You'll be able to go through that aspect. There's also talk of Benita being calm. Well, she knows what she just did, and the police are here, so she needs to be calm. Plus, she wasn't the one attacked. Shemaya was upset because she had been attacked twice by somebody who's her aunt, who's not supposed to do those things to somebody. You're looking at what happened on this occasion, on this day, the elements of this. It's not about the investigation at this point. It's not about she helped Shemaya out. Of course she's helped Shemaya out. Shemaya admitted that. They are family, but that doesn't excuse what happened. So when you have an individual that is angry, treats their niece, holding her down, holding her by her neck, causing those injuries, you know what you're doing. She knew what she was doing. It's not about whether I intended to hurt her or I didn't. She knew what she was doing. She knew her actions could cause and did cause injury to both the throat as well as her face. She didn't feel every injury when the officers were there. They didn't have her remove her clothing. They didn't look at other areas of her body. They were looking at the obvious injuries. She had adrenaline pumping. She was upset. They were taking what they saw. When she had additional injuries that were consistent with how she explained Benita being on top of her, it made sense. Those injuries are consistent with what she has said. She's been consistent throughout. You heard all the testimony. You heard how paramedic Dobska did assess her for head trauma. He doesn't diagnose concussions, but he assessed for head trauma. She told him she was having difficulty breathing. She had medical people look at her. Not everybody goes to the hospital. It's nighttime, her child is there. She's just been through a trauma. She's stayed at home. Nobody said that she was dying on the ground. She was held down. She was having trouble breathing. She was scared of what could happen because it could have been serious physical harm. Thankfully, it was not. But her actions, Benita Fryer's actions, could have caused a substantial risk of serious physical harm. And you saw the harm that was done, and you will be able to look at it further. But please remember your recollection, hold and follow the instructions of the judge, and we are confident that you will find Benita Fryer guilty of all 5 counts. Thank you.
Thank you. All right, we'll pick back up on page 9 if you want to follow along in the instructions. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in light of and in harmony with all the instructions. The court has instructed you on all the law necessary for your deliberations. Whether or not certain instructions are applicable may depend upon the conclusions you reach on the facts. If you have an impression that the court has indicated how any disputed fact should be decided, You must put aside such an impression because that decision must be made by you based solely upon the facts presented to you in this courtroom. You may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. Circumstances in the case may arouse sympathy. Sympathy is a common human emotion. The law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not to permit it to influence your verdict. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your finding with intelligence and impartiality and without bias, sympathy, or prejudice, so the state and defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything you consider an indication of the court's view on the facts, you are instructed to disregard it. When you go to the jury room, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than any other jurors. He or she serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and any exhibits are returned to the court after you have reached a verdict. If you took notes during the trial, you may take your notes to the jury room. The fact that the notes taken by a juror support his or her recollection in no way makes his or her memory more reliable than that of the jurors who do not take notes. All notes will be returned to the bailiff for destruction when the jury is discharged. The court will place in your possession the exhibits, a copy of the jury instructions, and the verdict form. The foreperson will retain possession of these records, including the verdict, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to immediately express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. In order to return a verdict, it is necessary that all jurors agree. Your verdict must be unanimous. Your verdict must be based solely on the evidence and on the law as the court has given it to you in these instructions. Nothing that the court has said or done is intended to suggest what your verdict should be. That is entirely for you to decide. If you have a question or request during the deliberations, your foreperson should write that question or request on a paper and notify the bailiff so the question or request can be delivered to me. Court cautions you, however, with regard to any message or questions you might send, that you should not reveal your numerical division at the time or the status of your deliberations. It should be reduced to writing so they're understanding as to what you request. It should then be delivered to the bailiff, who will submit it to the court. When all 12 jurors agree upon a verdict, you will sign the verdict and advise the bailiff by using the buzzer in the jury room. You will then be returned to the courtroom. As mentioned earlier, you have heard all the evidence. It is common practice when jurors commence deliberations to request transcripts of various witnesses. There are no transcripts. Juror number 6, you were selected in the event of any misfortune to any member of the panel. At this point, you will not accompany the jury to the jury room or participate in deliberations unless directed by the court. Please remain in the courthouse until the court directs you. It will not be necessary for you to serve any further. You are not to discuss this case or tell anyone how you would have voted until after the jury has returned a verdict. After you are discharged, you may discuss your verdict and your deliberations with others, but you are not required to do so. You must decide for yourself whether or not to discuss such matters. It is a lawyer's duty to protect your desire not to talk about the case if that is your decision. It is improper and unethical for a lawyer or anyone else to harass, entice, or exert improper influence on you for the purpose of getting you to talk about the case. Once 12 members of the jury have agreed to a verdict on each of the counts and have signed the corresponding verdict forms, the foreperson will notify the bailiff and you will be returned to the courtroom. You may now start your deliberations. All right, they're going to stay as long as they want to stay, so.
Okay.
We'll see.
Yes, Judge. I'm gonna take a walk. Sit down. Junior got a baseball game and missed it.
This one wasn't identified or anything.
Oh, okay, all right. Cool. Yeah, we had a game yesterday, I missed it. They told me he might play.
We did last time.
Did you guys really go in the room?
Not actually, but we put guesses.
Oh, come on.
I know, my legs are killing me. I stood up and I was like, oh my gosh.
Where did the stickies go? Where did the Post-its just go? Oh, no, I know how to spell it, I don't know how to post it.
Who said I didn't touch them?
There were 2 sticks.
Well, we know how.
Where did I put this?
No.
She ripped them off, yeah.
I was just trying to be cleanly.
Okay, so that is.
Like earlier when